pray that it may come up on Wednesday because a lot of part hurt matters are there. Hearing cases are above it.
All right, item 23. Who's appearing?
RK Chaudhary.
When do you want it?
Let it be on Wednesday, ma'am.
Wednesday for hearing.
Or Thursday, ma'am. Or
Thursday.
today, if you're not sure, I'll give the upgradation, my lord.
Upgradation may not be possible, but if,
Lordship, 21st, sir, is not available.
22nd.
21st, some difficulty is there, Lordship.
all right, 26th.
26th.
26th item. 23. The
23.
request of
23rd.
no, your item is 23.
23.
We are fixing it on 26th. 26th.
On that day, my lord, if it goes below, my lord, lordship will allow-
Please make a mention in the morning.
May I please your lordship? Lordship, with the consent from the other side, I beg to mention item number 16 for adjournment. As my senior Mr. SKMD is out of state.
1-6.
1-6. It may be
1-6.
fixed, Lord.
1-6 adjourned at the request of Mr. So-and-so on behalf of Mr. SKMD. It is submitted that consent for the petitioner has been taken. All right.
My lord, on the last occasion, it had fallen from the lordship that we should also look into FR and SR. My lord, I consulted FR and SR, and my lord, I could not lay my hand on anything relevant connected with the issue in hand. Actually, my lord, counting of past services in an equivalent post is a judicially evolved principle. And my lord, service law is basically a judge's made law. So, considering the judicial precedents, namely the two previous cases of the Supreme Court, which were referred in SI Rupal, this principle has evolved. That past services in an equivalent post should be counted for the purpose of seniority. So it is this principle, my lord, I am placing my reliance on. And my lord, secondly, on the last occasion, my lord, in course of the interaction, it fell from my esteemed colleague. He suggested, in fact, though, my lord, there is no pleading to that effect in the affidavit in opposition, namely that after the vacation of the interim order by this honorable court and dismissal of the petition, when he submitted his representation during the intervening period, he was not in charge. My lord, I verified the facts from the junior my lord who was instructing me in this case, and my lord, the information is he was throughout in charge. He was discharging his official duties. It is incorrect. In any case, my lord, there is no pleading.
In spite of the vacation or in spite of non-extension of the order.
Because, my lord, there was nothing to the contrary also.
Yes.
So that's it, my lord. And
You are relying on.
SI Rupal, my lord, namely the two paragraphs wherein this principle has been
No, you take
explained,
us.
para 17 and para 19.
Take us through the judgment properly.
Yes. Para 17, my lord, to begin with.
No, let us find out what are the facts involved in the case.
Oh, very well, very well. My lord, the synopsis of the facts of the present case is given in page 645 of the SEC itself. That synopsis I will read. That explains the entire case.
Synopsis.
Synopsis given in the SEC of the very judgment. The facts are given.
The head notes.
Yes, my lord, but synopsis is
So
there.
let's
Yes.
go to the proper
I call
paragraph.
it synopsis only, my lord,
go
because
to the
it's not
proper
exactly the
paragraph.
head note. They explain the facts of the case for our benefit.
So let us go through the facts. You can start from para 2 onwards or 3 onwards if you want.
Lord, anyway, I'll just read that portion, then I will go through the facts.
All right.
Page 645.
Yes.
The appellants, I'm sorry, whether my lord has,
Yes.
whether
please
my
get-
lord is having the SEC.
Yes, I have the assistant.
The appellants were sub-inspectors of Border Security Force who were initially taken on deputation in Delhi Police as sub-inspectors executive and were later on absorbed in Delhi Police in the same capacity. While fixing their seniority in Delhi Police service already rendered by them as sub-inspector in BSF was not taken into consideration on the ground that pay scale of sub-inspector in BSF was not equivalent to pay scale in Delhi Police. Besides, the respondents also relied on Government of India Office Memorandum dated 29/5/1986 to support their action. Clause 4 of the OM reads as follows. In the case of a person who is initially taken on deputation and absorbed letter where the relevant recruitment rules provided transfer on deputation is to transfer, his seniority in the grade in which he is absorbed will normally be counted from the date of absorption. If he has already been holding on the date of absorption the same or equivalent grade on regular basis in his parent department, such regular service in the grade shall also be taken into account in fixing his seniority, subject to the condition that he will be given seniority from the date he has been holding the post on deputation or the date from which he has been appointed on a regular basis to the same or equivalent grade in his parent department, whichever is later. Earlier, there was a similar case in which the Central Administrative Tribunal had held that benefit of service already rendered in parent department could not be denied. But in the present case, the tribunal, instead of honoring its earlier precedent, held that the appellants were not entitled to benefit of service rendered by them as sub-inspector in their parent department, that is BSF. The Supreme Court, apart from considering validity of the order of the tribunal, also considered constitutional validity of the expression, quote, whichever is later, unquote, occurring in the office memorandum. This expression was challenged as violative of Article 14 and 16. So this is it, my lord, the facts in brief. Thank you.
Yes,
Please, sir. So just now, my lord, actually I was informed that my case is being called in the court number 1, so I have sent my junior. I'm sorry. These difficulties are always there.
yes,
Below the judgment, then I start from paragraph 2 of the judgment. Page 650.
yes,
In all the above cases, the question involved is whether a sub-inspector who was appointed as such in the Border Security Force for BSF when transferred on deputation to the Delhi Police in the cadre of sub-inspector executive on being permanently absorbed in the transferred post is entitled to count his substantive service as sub-inspector in BSF for the purpose of his seniority in the cadre of sub-inspector executive in the Delhi Police or not. So, my lord, just basically the principle itself, my lord, came up before the court, whether it is proper or not. To appreciate the controversy involved in these cases, it is necessary to note the background of these transfers from various police organizations to the Delhi Police. A perusal of the letter issued by the Commissioner of Police, Delhi number such and such, dated 10/9/85 shows that in the year 1985, with a view to strengthen the existing security system in the capital, the Delhi Police had created 12 new police stations in Delhi. Consequent to the same, and in view of the prevailing conditions, it was felt necessary to fill up the required posts in the Delhi Police within the shortest possible time, so that there was an immediate impact on the law and order situation in Delhi. In the said letter, the commissioner noted that in the normal course, the recruitment at different levels and training of the recruits would take a longer time. And in view of the urgent need of the hour, a decision was taken to take suitable persons on deputation in the ranks of inspector, sub-inspector, assistant sub-inspector, head constable, constable and driver, head constable and constable. In the said letter, a request was made to the Director General of BSF to forward the names of suitable persons desirous of joining the Delhi Police on initial deputation for a period of 1 year. The letter also stated that those officials taken on deputation were likely to be considered for permanent absorption after 1 year if they were found suitable. From the above letter, it is clear that the Delhi Police were in dire need of additional hands to man the 12 newly created police stations in Delhi. In this background, certain sub-inspectors who were working in BSF were at first sent to deputation to the Delhi Police in the cadre of sub-inspector executive, and subsequently they were permanently absorbed. The Delhi Police Appointment and Recruitment Rules 1980 provide for the mode of recruitment in the Delhi Police. Rule 5H of the said rules provides that if the commissioner is of the opinion that it is necessary or expedient in the interest of work to do so, he may make appointment to all non-gazetted categories of both executive and ministerial cadres of the Delhi police on deputation basis. By drawing suitable persons from any other state, union territory, central police organization, or any other force. It is not in dispute that in exercise of the said power, the appellants herein and other similarly situated persons were deputed on transfer from BSF to the Delhi police. Rule 17 of the above rules, which was incorporated on 31/3/1983, empowers the Commissioner of Police, Delhi, to sanction permanent absorption of persons sent on deputation with the consent of the deputed official in the Delhi police of upper and lower subordinates, and with the concurrence of the head of police force from which the said official is deputed. It is also not in dispute that the absorption of the appellants and other similarly situated officials in the Delhi police in the cadre of sub-inspector executive was done in exercise of the above power vested in the commissioner under Rule 17 of the rules. In view of the fact that when the interstate seniority list of the sub-inspectors in the Delhi police was drawn, the authorities concerned did not take into consideration the service put in by the transferee officials like the appellants in their parent department, namely BSF. One of the aggrieved persons by the name of Anthony Matthew filed an application before the Central Administrative Tribunal in OA number such and such, wherein he claimed that for determination of his seniority in the Delhi police, the date of his continuous officiation on a substantive basis as sub-inspector in BSF has to be counted. A principal bench of the tribunal in the said application, while its judgment dated 2/3/93 held as follows. The petitioner was appointed as sub-inspector in Border Security Force on 21/4/80. He was appointed as sub-inspector on substantive basis with effect from 1/10/84. He came to be sent on deputation basis to Delhi police on 19/11/85. He came to be absorbed in the Delhi police in the same grade of sub-inspector with effect from 19/6/87. He has in due course been confirmed in that position. The petitioner's claim in this case is for determining his seniority, taking into consideration the date of continuous officiation as sub-inspector in the Border Security Force from 21/4/80, on which date he was appointed as sub-inspector in the Border Security Force with effect from 1/10/84, the date of his substantive appointment in the Border Security Force. The respondents have decided to accord seniority to the petitioner with effect from the date of his absorption, namely 19/6/87. The contention of the petitioner is that he is entitled to the benefit of service rendered by him with the Border Security Force for the purpose of reckoning his seniority. So far as the principle of law is concerned, the learned counsel for the petitioner relies upon the judgment of the Supreme Court in K. Madhavan versus Union of India. The relevant discussion in para 21 of the judgment makes it clear that full credit must be given to the petitioner for the services rendered by him on a substantive basis in the Border Security Force with effect from 1/10/84. The petitioner contends that he should be given seniority taking the date of his initial appointment, or in the alternative, his seniority may be counted with effect from 1/10/84 when he was appointed on substantive basis with the Border Security Force. The petitioner has not produced any material showing that he was appointed with effect from 21/4/80 on permanent basis. In the absence of clear material, he will not be justified in taking 21/4/80 as the correct date. There is no dispute that the petitioner was appointed as sub-inspector with the Border Security Force with effect from 1/10/84 on a substantive basis. That is the date which should be taken into account for determining the seniority of the petitioner. For the reasons stated above, this petition is allowed. The respondents are directed to accord seniority to the petitioner in the Delhi police taking 1/10/84 as the date of appointment as sub-inspector in the Border Security Force on a substantive basis. He shall be accorded all other benefits flowing from determination of such seniority, no cause. Then it is seen from the above order of the tribunal that it relied upon a judgment of this court in the case of K. Madhavan versus Union of India, which judgment required that full credit must be given to the official for substantive service in the equivalent post in the transfer department while computing his seniority in the transfer department. The Delhi administration, which was respondent in the said application, filed a review petition against the said judgment of the tribunal, urging new ground, inter alia, that the post of sub-inspector in BSF was not equivalent to the post of sub-inspector in the Delhi police because the pay scales of the two posts were not the same. Hence, their service in the parent department cannot be counted for seniority in the transferred post. the said review petition came to be dismissed by the tribunal by a reasoned order. It held that equal pay scales was not the sole determinative factor while determining the equivalency of the two posts. It also reiterated its finding that the law laid down by this court in Madhavan case was applicable on all fours to the facts of the case. On not being satisfied with the order of the tribunal, in the review application also, the respondent filed an SLP before this court against the original judgment and the order in review white such and such of 1993. In the said SLP, the respondent specifically contended that the ratio of this court in Madhavan case was not applicable to the case of Anthony Matthew.
Was Madhavan upheld?
Yes, my lord, Madhavan also. It is nothing, my lord. Madhavan and thereafter, my lord, the Joginder Kumar and the Meenakshi, the court also reiterated the same principle. Was not applicable to the case of Anthony Matthew on the ground that the post held by Anthony Matthew in BSF was not equivalent to the post of sub-inspector in the Delhi police. A three-judge bench of this court, while its order dated 22/4/94, found no merit in the petition filed by the Delhi administration and dismissed the same. It is worthwhile to note that the above referred dismissal order of this court shows that the respondents in the SLP were represented by a counsel and the court passed an order after hearing the counsel. Strangely enough, the respondent, which was the employer of both the originally recruited sub-inspectors of the Delhi police as well as subsequently transferred and absorbed officials, was still not satisfied even with this decision of the apex court and filed a review petition against the said order of dismissal of the SLP, which review came to be dismissed by this court with the following order. Apart from the fact that petitions are delayed by 444 days, even on merits, we see no reason to detain these petitions. Hence, the review petitions are dismissed. So, review was also dismissed. Thus, the first boot of litigation, which originated with regard to a simple question of counting of seniority in the year 1991, came to an end in February 96. But so far as the respondent is concerned, it was not prepared to accept the law laid down in Anthony Matthew case. Though it gave the benefit of the order of the tribunal as affirmed by this court to Anthony Matthew, it was not ready to extend the same benefit to the persons similarly situated like the appellants herein. As stated above, the appellants were also originally appointed like Anthony Matthew in BSF as sub-inspectors and subsequently transferred and absorbed as such in the Delhi police force. And as a matter of fact, the first appellant was even senior to Anthony Matthew in the cadre of sub-inspectors in BSF, as was also absorbed in Delhi police on a date anterior to that of Anthony Matthew. The refusal of Delhi administration to give benefit of the judgment in the case of Anthony Matthew to the appellants, despite their repeated representations and consequent denial of their seniority, compelled these appellants to file original applications being OA number such and such before another principal bench of CAT at Delhi. Surprisingly, even though the case of the applicants before the tribunal in the above referred original applications from which the present civil appeals arise was identical to the case of Anthony Matthew, both on facts and in law, the tribunal in total disregard to the rule of precedents, in spite of having noticed the earlier judgment of a coordinate bench of the same tribunal and having noticed the fact that the review petition filed before the tribunal, SLP filed before this court, and review petition filed before this court were dismissed, it is still proceeded to consider the application independent of the law laid down in the previous case and came to an entirely contra conclusion and further held that the judgment in Madhavan case had no bearing to the facts of the present case. In this process, it relied on an official memorandum dated 29/5/86, the existence of which was unknown to all concerned and reference to which was not made by the respondent either as a defense in the original application of Anthony Matthew case or in review filed thereafter or before this court in the SLP or in the review petition filed before this court. In the second round of litigation, the tribunal came to the conclusion that the post held by the present appellants in BSF was not an equivalent post of sub-inspector in the Delhi police, and also in view of the language employed in the OM dated 29/5/86, held that the appellants herein were not entitled to count the service rendered by them prior to their absorption in the Delhi police for the purpose of their seniority in the cadre of sub-inspector executive with the Delhi police. It is against this order of the tribunal that the appellants have preferred SLPs in which leave to appeal was granted by this court. So, my lord, earlier precedent, everything was given a total go by the tribunal, and then, my lord, it went contra to its own earlier precedent. And that is how, my lord, the present case arose before the Supreme Court. The facts, my lord, we have already noted, and, my lord, the law very succinctly the Supreme Court explained in paragraph 17 and in paragraph 19.
Yes.
The para 17, my lord, I'll just read.
Yes.
In law, it is necessary that if the previous service of a transferred official is to be counted for seniority in the transferred post, then the two posts should be equivalent. That is the basic axiomatic principle. One of the objections raised by the respondent in this case, as well as in the earlier case of Anthony Matthew, is that the post of sub-inspector in BSF is not equivalent to the post of sub-inspector executive in Delhi police. And the argument was pay scale is different. So, below this paragraph I read out in extenso yesterday. The court said no, pay scale may not be similar, even then the post may be equivalent. That by itself is not the criteria. Then the court discussed the principles in paragraph 17. And then, my lord, in 19, para 19, I'll just read.
There is a reference to some memorandum.
My lord, yes, but my lord,
What
even
is that?
divorce the memorandum.
What is that memorandum?
Memorandum is of the government of India.
Is it?
The memorandum says that if in the event of an absorption to an equivalent post, the past services should be considered. But may not even divorce the memorandum. The Supreme Court discussed the basic principle. Lordship would see it is very evident from the language by itself.
Para 19.
Yes, this leaves us to consider the validity of the office memorandum, which was relied upon by the tribunal in the impugned judgment. We have noticed earlier in the judgment that the constitutional validity of this memorandum is independently challenged by the appellants in WPC number such and such. There is considerable force in the argument addressed on behalf of the appellants that this memorandum had neither been made public nor the existence thereof made known to anybody concerned with the controversy in question. We have already referred to this fact. Hence, we do not want to repeat the same in detail. On facts, we are of the opinion that the respondents ought not to have been permitted to rely upon this document because there is no material whatsoever produced by the respondents to show that this memorandum, which was issued by the government of India, was either ipso facto applicable to Delhi police force or the same was adopted and applied by the Delhi police force. Then, my lord, comes the real catch. It is to be noted that the law in regard to the right of a deputationist to count his service for the purpose of seniority in the transfer department was settled as far back as in the year 82 itself, in the case of R.S. Makashi and Wing Commander Joginder Kumar, if not earlier. So that is the basic judicially evolved principle, leaving aside all other consideration. Therefore, it is reasonable to expect, and it's still vital, my lord, therefore it is reasonable to expect that a deputationist, when his service is sought to be absorbed in the transfer department, would certainly have expected that his seniority in the parent department would be counted. Now, court has gone into the legitimate expectation that he would expect it, because this is the principle. Otherwise, why should I say that no, absorb me over here? In such a situation, it was really the duty of the respondents, if at all, the conditions stipulated in the impugned memorandum were applicable to such person to have made the conditions in the memorandum known to the deputationist before absorbing his services in all fairness, so that such a deputationist would have had the option of accepting the permanent absorption in the Delhi police or not. My lord, in answer to this, I would say likewise, in the state of Assam, the respondent could have informed me that, look here, we don't have any such policy. We would not, if you are absorbed, your seniority will be counted only from the date of absorption as deputy director such and such. The past services will not be counted. Had they told me, I would have gone back to my parent department, because in that case, in any case, I was holding the lien. The lien was operational. So therefore, my lord, state of Assam having not done that.
There is no memorandum of the same nature here.
Certainly, at the same time, there is nothing to the contrary also. So, my lord, when there is nothing to the contrary, when FR and SR are silent, naturally, my lord, I would latch on to the judicially evolved principle. That this is the principle, I have the legitimate expectation. Now, when you do not count my seniority, I am highly prejudiced.
Okay.
That's my case, my lord.
Yes.
My lord, may I, my lord, take leave, because it seems, my lord, appellants have started arguments over there in the court number 1. My lord, I'm sorry, my lord.
No. We can't detain you, of course. Yes.
My lord. My lord, the facts of this case, my lord, present case is very little different from the other case of the apex court order, my lord. Because, my lord, I like to relay some pages again, my lord, in the writ petition, my lord.
Yes.
Before starting, my lord, DRDA is a different entity of from the PNRD department, my lord. Lordship is very much aware that DRDA is a society, my lord, and it's a independent body, and it's under a scheme, my lord, and 90% financed by the central fund and 10% from the state fund, my lord. And now Lordship may kindly come to page number 46 first, my lord.
Yes.
46 is the order, my lord, by where the petitioner's parent department has deputed him, my lord. May I read, my lord?
Hmm.
The governor of Assam is pleased to place the services of Sri Sofiul Alam, the petitioner, my lord, the AEO of the department at the disposal of Panchayat and Rural Development Department as APO Agriculture in DRDA on deputation initially for a period of 1 year. His deputation was in the DRDA, my lord, which is under the PNRD department. Thereafter, Lordship may kindly, I'm sorry, my lord, number 3 and 4 may be kindly seen, my lord. There are some conditions. Point number 3, liabilities for payment of leave, salary, pension contribution will be borne by the foreign employer, that is the DRDA, not PNRD, my lord, DRDA. And the number 4, the deputation vacancy should be not be filled up. That means he is in lien, my lord.
No, he's deputed to which department?
DRDA, my lord. It's DRDA
Kindly-
is
kindly-
under Panchayat, my lord.
Kindly read the opening lines of this.
Yes, my lord.
notification.
The governor of Assam is pleased to place the service of Sri Sofiul Alam AEO of this department at the disposal of Panchayat and Rural Development Department
Basically-
in DRDA, my lord.
But at the disposal of the department.
My lord, this is the order from his parent department, and there are some other documents also which we'll see, my lord.
All right.
His appointment reputation was only on DRDA, not in the PNRD directly, my lord. Because, my lord, I'll come to that, my lord. Lordship may kindly next page 49, my lord. For a moment.
Yes.
Page 49, may I read, my lord, from the on his service being placed at the disposal of the department by irrigation department, by their notification so and so, the Sofiul Alam Agricultural Extension Officer is appointed as Assistant Project Officer Agricultural on deputation in his grade pay and allowances admissible and posted to the District Rural Development Agency Golaghat against the existing vacancy which effect from the date of taking over the charge. My lord, there is no post called Assistant Project Officer Agriculture in the PNRD department, my lord. This is a post under the DRDA only, my lord. Now, Lordship may kindly come to page number 58 for a moment, my lord.
Yes.
In the interest of public service, the service of the following assistant project officer are replaced at the disposal of Agriculture Irrigation Department with immediate effect. By this order, my lord, he was replaced to the parent department, my lord. And Lordship may kindly see at serial number 1, present place of posting, DRDA Kokrajhar.
Yes.
Yes. The 4, my lord, the copy 2, the 4, number 0.4, copy 2, the project director, DRDA Kokrajhar, and so, to the officer of the concerned DRDA to enable him to join his parent department immediately. So the DRDA Kokrajhar was advised to release him so that he can go back to the parent department, my lord. Thereafter, Lordship may kindly come to page number 68 for a moment, my lord. This is the cabinet memorandum, my lord.
Hmm.
Point number 1.
Yes.
Yes. May I read point number 1, page 68.
68, yes.
68, my lord. This is the cabinet memorandum, my lord, copy. May I read, my lord? The service of Sri Sofiul Alam Agricultural Extension Officer, Irrigation Department was initially placed at the disposal of the Panchayat and Rural Development Department on deputation, by notification dated so and so, and accordingly he was posted as Assistant Project Officer Agriculture at DRDA headquarters. And I am repeating, my lord, that there is no
What
post.
is the interpretation or what is the meaning that you'd like to ascribe to the words that he is placed at the disposal of the department?
My lord, that
What is your interpretation?
because I'll cite a judgment, my lord, so apex court judgment,
Hmm.
that will clarify my position, my lord.
Right.
That is why I am submitting, my lord. Then place 68B, my lord. Point 5.
Yes.
68B. Under the above stated circumstances, the Panchayat and Rural Development Department considered the representation submitted by Sofiul Alam, Assistant Project Officer Agriculture, and initiated process for permanent absorption of the officer concerned. But since Sri Sofiul Alam was on deputation as Assistant Project Officer Agriculture in DRDA, which is a society post, it has been decided to absorb him against any vacant equivalent post under the establishment of Commissioner and Panchayat and Rural Development Department. The proposal was that, my lord, that as he was working in a society post, the proposal was sent to permanently absorb in the Panchayat Department Commissionerate Office, my lord.
He was deputed to PNRD.
But he was posted in a DRDA.
Posting may be anywhere.
That way I will come for that query, my lord, for Lordship's query.
Yes.
Yes. Now, Lordship may kindly come to page 69A.
69.
A, my lord.
Yes.
Point 8 and 9 I am reading, my lord. 69A. With the views and concurrence of the concerned referral departments, wide their endorsement deposited above, the Panchayat and Rural Development Department decided to permanently absorb the service of the Sofiul Alam, the Agriculture Extension Officer, Irrigation Department, under deputation as Assistant Project Officer Agriculture at DRDA headquarters, Nagaon. That means, my lord, he was continuing in the DRDA Nagaon, my lord, till that day, my lord, with the approval of the Honorable Cabinet. Now, paragraph 9, my lord. As such, the matter is placed before the Honorable Cabinet for kind approval towards permanent absorption of the services of Sofiul Alam, Agriculture Extension Officer, Irrigation Department, under deputation as Assistant Project Officer Agriculture at DRDA headquarters, Nagaon, to any vacant post equivalent post under the establishment of the Commissioner Panchayat and Rural Development Department, and which relaxation of the relevant rules. That means, my lord, he was till that day, my lord, 15/12/2015, he was not holding a post which was an establishment of the Commissioner Panchayat, my lord. Therefore, he was proposed to post in an equivalent post in the Department of Panchayat and Rural Development Department, my lord. And now page number 71 for a moment, my lord. This is the approval order, my lord, of the petitioner. Permanent absorption of service of Sofiul Alam, Assistant Project Officer Agriculture, DRDA, headquarters, Nagaon, under the establishment of Commissioner Panchayat and Rural Development Department, approved. So he was approved from the DRDA to the Panchayat Department, my lord. Now I would like to place one judgment of apex court, my lord, after the Rupla judgment case, my lord. This is 2006 8 SCC 129, Indu Shekhar Singh and others versus State of UP and others, my lord. Relevant paragraphs are, my lord, I have written in the top, my lord. First, Lordship may kindly come to paragraph 19 first, my lord.
Yes.
Before starting, may I read the head notes, my lord, for a moment, my lord?
Don't read the
Yes,
notes,
yes,
you
sorry.
read the paragraph.
Paragraph 19. Head notes is clarify
Instead of reading
all my submissions, my lord. That is why, my
You read
paragraph 19,
11 paragraphs.
paragraph 19, my lord.
Yes.
The terms and conditions of recruitment, appointment to the post seniority and other terms and conditions of service are governed by statutory rules. The statute provides that only those who were in the employment of different development authorities, in that case, my lord, he was absorbed in the development authority, my lord, shall be born to the cadre of the central services. The UP Jal Nigam was not a development authority. It was constituted under a different statute. In our case, he was working in a DRDA, my lord. It was an autonomous body. The employees working with the Jal Nigam might have been deputed to the services of the development authorities, but only by reason thereof, they did not derive any right to be absorbed in the services. Ordinarily, an employee has no legal right to be deputed to another organization. He has also no right to be permanently absorbed, excepting in certain situation, as was held by this court in so-and-so union.
There is no quarrel with this proposition.
My lord, there
Why are you
there
reading
is
this?
paragraphs, my lord. Lordship, may kindly next
Show us, has
Yes, yes.
Ruplal been,
paragraph 22.
Mr. Counsel, has Ruplal being distinguished here?
My lord, yes,
Yes, can you
Yes.
take us to that?
yes,
paragraph?
yes. I am coming to serially, my lord.
No,
Only
you
six,
take
seven.
us to that paragraph straight away.
Yes, next paragraph. Can I read my paragraphs, my lord, which I am relying, my lord?
No, you take us to that paragraph to show us that it has been distinguished. You will come back.
Yes, yes, my lord. Okay, my lord. Ruplal is at page number 43, my lord. Paragraph number 43, my lord.
Yes.
Yes. Having noticed the aforementioned decisions of this court, we may now notice Sub-Inspector Ruplal, which is the sheet and core of the judgment rendered by the High Court. In that case, this court was concerned with interpretation of Rule 5H of the Delhi Police Appointment and Recruitment Rules 1980, providing that if the commissioner is of the opinion that it is necessary or expedient in the interest of work so to do, he may make appointments to all non-gazetted categories of both executive and ministerial cadres of the Delhi Police on deputation basis and by drawing suitable persons from any other state, union territory, central place, organization, or any other force. The appellants therein were deputed on transfer from BSF to Delhi Police pursuant to the aforementioned provisions. Rule 5H of the said rules empowered the authority to appoint the employees of other departments drawn by way of deputation, depending upon the need of the Delhi Police. There was no seniority rule. Seniority in that case was sought to be determined by way of executive order, which in turn was issued on the basis of a memorandum dated 29/5/1986, issued by the Government of India. The memorandum in question was neither made public nor the existence thereof was made known to any person involved in the controversy. The said memorandum was not made ipso facto applicable to the employees. In the aforementioned factual backdrop referring to R.S. Makashi and Wing Commander J. Kumar, this court observed, therefore, it is reasonable to accept that a deputationist, when his service is sought to be absorbed in the transport department, would certainly have expected that his seniority in the parent department would be counted. In such a situation, it was really the duty of the respondents, if at all the conditions stipulated in the impugned memorandum were applicable to such person, to have made the conditions in the memorandum known to the deputationist before absorbing his service. In all fairnesses, so that such a deputationist would have had the option to accepting the permanent absorption in the Delhi Police or not. This is the case discussed in this matter case, my lord.
Then what is the final?
If we go by the paragraph 47 and 48, my lord,
Yes.
47, for the said reasons, only the executive instruction was held to be ultra vires Article 14 and 16 of the Constitution of India. It was further hold that by reason of the memorandum impugned therein, the right of the deputationist could not have been taken away. And in that view of the matter, the offending part of the memorandum was struck down. The prayed as prayed in the writ petition, the rights of the appellants were held to have been preserved, and the words which is later were held to be ultra vires, Article 14 and 16 of the Constitution. Next, my lord, 47 and 48. The decisions referred to herein before therefore lay down a law that past services would only be directed to be counted towards seniority in two situations. One, when there exists a rule directing consideration of seniority, there is no rule in our case, my lord. And number two, where recruitments are made from various sources, it would be reasonable to frame a rule considering the past services of the employees concerned. This is also not applicable in our case, my lord. And paragraph 48, the said decisions in our considered view have no application in this case, having regard to the provision of section 5A of the Act, in terms whereof no provision exists for recruitment of deputationists. Recruitment of deputationists, in fact, is excluded therefrom.
What is this 5A?
5A was there is in that, in this case, my lord, there is a provision, my lord, by which their rights were cut down, my lord. There some conditions were also imposed.
So what was the finding of the court in respect
lord.
of 5A?
55 paragraph, my lord. It was thus open to the respondents herein not to agree to, in spite of the said conditions, as they had already been working with a statutory authority. They, however, expressly consented to do so. They must have exercised their opinion, having regard to benefits to which they were entitled to in the new post. One such option is exercised, the consequences attached thereto would ensue. Thereafter, lordship, the appeals were allowed, my lord. And also paragraph 25 and 26 is very relevant, my lord.
Yes, please read.
22, 23, 25, 26.
Please read.
No, may I read 22 first, my lord? The seniority, as is well settled, is not a fundamental right. It is merely a civil right, my lord. See so and so, so and so. And paragraph 23, my lord, the High Court evidently proceeded on the premises that the seniority is a fundamental right, and thereby, in our opinion, committed a manifest error. Now, lordship, 25, my lord. The state was making an offer to the respondents not in terms of any specific power under the rule, but in exercise of its residuary power, assuming that the same was available. In our case, my lord, state not offered. The petitioner offered that he may be finally observed in the department, my lord, after the High Court case, my lord. The state, therefore, was within its right to impose conditions. The respondents exercised their right of election. They could have accepted the said offer or rejected the same. While making the said offer, the state categorically stated that for the purpose of fixation of seniority, they would not be obtaining the benefits of service rendered in the UP Jal Nigam, in our case DRDA, my lord, and would be placed below in the cadre till the date of absorption. The submission of Mr. So-and-so that the period for which they were with the authority by way of deputation should have been considered towards seniority cannot be accepted simply for the reason that till they were absorbed, they continued to be in the employment of the Jal Nigam. Furthermore, the said conditions imposed is backed by another condition that the reputed employee who is seeking for absorption shall be placed below the officer appointed in the cadre till the date of absorption. Respondent number 2 to 4 accepted the said offer without any demur on 3/9/1987. 28/11/1991 and so respectively. And 26, they therefore exercise their right of option once they have obtained entry on the basis of election. They cannot be allowed to turn round and contended that the conditions are illegal. In furthermore, there is no fundamental right in regard to the counting of the service rendered in an autonomous body. The past services can be taken into consideration only when the rules permit the same or where a special situation exists, which would entitle the employee to obtain such benefit to the past service. In my humble submission, my lord, the petitioner was deputed to a DRDA, my lord, till the final absorption date, my lord. And final absorption date, my lord, has a condition that his date of joining will be counted from the joining in the Panchayat and Rural Development Department, my lord. And in the proposal was also that proposal, the office, the memorandum.
In this case,
My lord,
under that relevant section 5,
my lord.
what were the conditions? Please
Yes,
point
my
out the condition.
In page number 131, there is a mention, my lord. The respondents were deputed to Ghaziabad Development Authority on their own. They were presumed to be aware that they were not born in the cadre of
You are referring to,
centralized services. The rules do not provide for appointment by way of transfer.
you are
There is no
referring from which page?
131, my lord. It's a part of head note.
So why do you keep referring to the head?
My lord,
notes?
my lord. I'm referring, my lord. Okay.
For your benefit, we'll refer to the head note.
My lord,
Just to point out one condition, come to page number 130.
my lord.
Now you read the paragraph at placitum B,
My lord.
which is.
Highway may be one page 134, my lord. This is 5A, my lord. Page number 130.
Kindly,
Yes,
kindly,
5A,
kindly come to page 130,
my lord.
placitum B.
130, yes.
Hmm.
Since the UP Jal Nigam was not a development authority,
Now you come below that.
in view of
You come below that. Not in the same paragraph.
same paragraph, my lord.
Come 3-4 lines below that.
5A, yes, section 5A. However,
below that.
Respondents,
No, come to this line beginning with one of the conditions.
yes, my lord.
You take us to the relevant paragraph.
One of the said conditions was that their past services were rendered in the UP Jal Nigam would not be reckoned for the purpose of determination of seniority.
Now you point out to this particular clause in that section 5A. If it is available.
134 is the 134 page number.
134.
5A conditions, my lord, they're there. 5A, 1, notwithstanding anything to the contrary contained in section 5 or in any other law for the time being in force, the state government may at any time by notification create one or more development authorities, centralized services for such posts other than the post mentioned in subsection 4 of section 59 as the state government may deem fit, common to all the development authorities, and may prescribe the manner and conditions of recruitment to and the terms and conditions of service of persons appointed to such services. Upon creation of a development authority's centralized service, a person serving on the post included in such service immediately before such creation, not being a person governed by the UP Palika service rules so and so, or serving on deputation. Shall unless he opts, otherwise he absorb in such service. Finally, if he was already confirmed in his post, B, provisionally, if he was holding temporary of officiating appointment. These are the 5 AMI.
But where do you find the conditions? Referred to in page 130,
My lord.
Placitum B, we just read. There is a reference to a condition that their past services will not be reckoned.
My lord. Five A2, maybe my lord, five A2.
No, I am not. I am just reading out from the head notes as you pointed out.
Yes,
There is a reference to some condition.
yes, yes.
So you point out if this condition is available here. If this condition is available,
My lord.
then it is not similar to the case at hand.
Yes, yes.
Mr. Tiwari,
Lord, I'll explain. Let my learned friend conclude this.
your
submission.
learned friend has brought out this judgment to say it is
I can
distinguished.
distinguish it very easily. I'll explain everything, provided he completes the submission.
All right. Mr. Doctor,
My lord.
we can permit you to do your research in the middle of an argument.
Maybe. Reference is at para 20. Maybe that was from the head note, my lord. Paragraph 20, my lord. Respondents may read, my lord.
Yes.
Respondents 2 to 4 were deputed to the Ghaziabad Development Authority. On their own, they were presumed to be aware that they were not born in the cadre of centralized services. The rules do not provide for appointment by way of transfer. The appointment by way of absorption of a deputed employee would amount to fresh appointment, which may be subject to the offer given by the authority. The Development Authority is a statutory authority, so is the Jal Nigam. The schedules appended to the rules provided for posts to be filled up by promotion or by direct recruitment or by both. Schedule 4 provides for the posts which are outside the purview of the Public Service Commission and are required to be filled up by the promotion only. Whereas Schedule 5 specifies those posts which are outside the purview of the Public Service Commission but are to be filled up through direct recruitment only. It is not disputed that the UP has since issued a notification on 9/12/2002 whereby and whereunder Rule 7(1) of the 1985 rules stood substituted in terms whereof the past services of only those officers and employees were to be counted who would finally be absorbed in services in terms of Section 5(a)(2) of the Act on the creation of continuous length of service, including the service rendered in a development authority, Nagar Mahapalika, or improvement trust or similar post. Response number 2 to 4 were not and could not have been absorbed under Section 5(a)(2) of the Act, and thus evidently Rule 7(1) is not attracted. The only rule which provides for seniority is Rule 28, Rule 7 and 28, as noticed herein under. According different
That
chapters.
particular extract is not available here.
Exactly that particular I cannot find, my lord, but the
Therefore,
meaning, my lord, is the same, my lord.
yes. So there is some rule
My lord,
which specifies that past services will not be counted.
my lord. And in the, my lord,
If that is the case, then it is not applicable to
My
the
lord,
facts of your case.
the ratio of this case, the ratio, my lord,
Uh,
the paragraph 25, 26, 31, 43, 47, 48, my lord.
hmm.
The ratio of this case will help us, my lord. help the
What is that
department.
ratio? What is the ratio?
My lord, my lord. Ratio in this case, my lord, the employees were
These
working,
employees were not
deputed, my lord.
employees of their statutory corporations,
lord.
development corporations,
Yes, was
at
deputed
that point in time.
to Nigam, Jal Nigam, my lord,
Hmm.
which is not a
Development.
authority, my lord,
Development authority.
development
yes.
authority.
Yes.
And therefore, their past services were not counted,
In terms of a rule.
my lord. Yes, my lord.
So do you have any rule like that?
My lord, my lord. May I refer one more time, my lord? There is a condition, my lord. If there is no rule, then they cannot, my lord. They cannot claim, my lord. There are two situations only, my lord, where they can. Paragraph 47, my lord. The decisions referred to herein before, therefore lay down a law that past services would only be directed to be counted towards seniority in two situations. One, when there exists a rule directing consideration of seniority. In our case, there is no rule. And number two, where recruitments are made from various sources, it would be reasonable to frame a rule considering the past services of the employee concerned. This is not applicable in our case.
No, but this 47 has to be read in the context of a rule of that Jal Nigam which prohibits counting of past services.
Yes, there was a rule in that case.
Ah.
So court is
So
saying, my lord,
therefore 47 to
there is no rule.
to say that where unless there is a rule directing consideration of seniority, or you frame a new rule,
Yes.
because there is already a rule saying that your seniority will not be counted,
No.
subject to the correction.
My
This is
lord.
what I have read from the judgment.
My lord. The ratio is that, my lord, if there is no rule, they cannot claim,
No,
my lord.
I don't think that is the ratio.
And in present case, my lord, in the final absorption order, there is a condition that final absorption will be counted after the joining in the Panchayat and Rural Development Department, my lord.
Exactly.
That is the line, my lord, in the final absorption, and he accepted, my lord. And the best interpreter of the order is the issuing authority, my lord.
Hmm. Yes.
And moreover, my lord, when we reverted back, my lord, in the year 2010, till 2000, the passing of the order, my lord, the 2010, 23/8/2010, there was a stay order from the Honorable High Court, my lord. And lordship may kindly come to the High Court's order, my lord, at page 64 for a moment, my lord. Page 64
Yes,
of the writ petition.
yes, please.
Yes, my lord. Relevant portion is at page 65. Next page, my lord. 65.
Yes.
As a deputationist, the petitioner has got only a limited right. Irrespective of any policy decision, he cannot claim that having continued for few years. Page 65, my lord.
Mm.
As a deputationist, the petitioner has got only a limited right. Irrespective of any policy decision, he cannot claim that having continued for few years. He must be
This is-
absorbed in the.
There is no quarrel with this concept.
Yes.
There is no right for
After-
absorption.
After this order,
Ah.
the stay order was vacated, my lord.
Maybe, but
That means, my lord.
is this a proposition?
Yes,
Is-
yes, my lord.
Is
The
this a
earlier order
finding?
will
Kindly
remain-
listen to the court. Is this a finding to come to the conclusion
Yes.
that notwithstanding this observation, or in view of this observation, he will stand to lose his seniority?
My lord.
This is an observation with regard to whether he has any right for claiming absorption.
Absorption.
There's no right.
Yes.
There's no
Yes.
quarrel on this
Till
proposition.
that day, court had observed that he don't have any right to continue, my lord. And the earlier order.
No, but having
challenged-
accepted his right by the government, now what do you want to do with his seniority? That is the question.
Yes. Before that, my lord, this prayer of this writ petition, my lord,
Hmm.
that may be seen. They are not claiming seniority, my lord. In this writ petition, they are not claiming seniority. Lordship may kindly come to the prayer portion once again, page 38.
Yes.
Yes. Issue a writ in the nature of mandamus directing the respondent number so and so, government of Assam so and so, to give effect to the permanent absorption of the petitioner in post of deputy director training from 13/3/1999.
What is 13.3?
13/3/99, he was deputed to the DRDA initially. Thereafter, we have passed an order. We have reverted back to his parent department. Thereafter, after 5 years, he again approached our department to final absorption. So how he can claim that his final permanent absorption with effect from 13/9/99, my lord?
No. Kindly continue with the prayer.
Yes, with his entitled seniority and consequential promotions with all the other consequential service benefits.
Then. No, please,
He want, my lord.
please read the entire
Yes,
prayer.
yes. Services rules with effect from the date of his placement of services in the PNRD department in the post of deputy director training.
It's
This
still
means-
not complete.
Yes, my lord. I have read that.
No, it's still not complete.
The director training at the said post is vacant since 1/3/99.
That is his prayer.
Yes, but my submission in this regard is, my lord, he was not working against that post. He was working as a.
So therefore, you submit with record your submission,
My lord,
but to say that he did not have a prayer for claiming may not be correct.
yes, my lord.
That is what you
But that is
submitted.
only a rider prayer, my lord.
How can
Main
it-
prayer, my lord, is that his final absorption shall be treated as 13/3/99.
How can it be main prayer? It's a part of the same prayer.
My lord,
Yes.
my submission is that, my lord, that as he was not holding a post in the PNRD department, and only after the final absorption, he is holding a post as a deputy director training. Only the post was lying vacant since 1999. That will not create a right to the petitioner to count his service from the 1/3/1999, my lord.
Yes. Okay.
My lord. And he was working, my lord, from 2010 to his final absorption date 12/9/16. He was working in a DRDA without any authority, my lord. Without any valid legal authority, my lord. DRDA is a scheme, my lord. And as per in the scheme, he was working not in the Department of Panchayat department directly. DRDA is a society, my lord, autonomous body, which is under Panchayat and Rural Development Department and funded by 90% central government, 10% state government, my lord. And after the that order, whether his lien was continued in his parent department, that is also subject to the petitioner's my lord.
Yes,
We don't know that, my lord. That is my submission, my lord.
yes, Mr. Tiwari.
May not patiently,
He may lordship permission, finance department may.
Finance, okay, finance. What do you have to say?
I will be only relying on a Supreme Court decision, my lord.
No, no, no. Before you rely, you have to submit. What do you want to submit? Do you agree or disagree?
So that's what, my lord. Now here, my lord, the issue here is, my lord, with regard to, my lord, whether the past services rendered by the petitioner can be counted for the purpose of seniority, promotion, my lord, and other service benefits. Service benefits will mean and include, my lord, the pensionary benefits available to a person. Now, if, my lord, the seniority is counted, he will definitely have a claim, my lord, lay a claim on the pensionary benefits also. The seniority goes up, pension goes up. It is within that parameter. I will be only relying on one decision because here the admitted position, what I find, my lord, gather is that, my lord, admittedly the petitioner, prior to having been absorbed, my lord, he was working in a scheme. Now, whether a service, my lord, rendered by a person in a particular scheme who have been later on absorbed can be counted.
No. You have missed out one, the prequel to that submission. He was not transferred to, he was not deputed to DRDA. He was deputed to PNRD, posted in DRDA. Now, under those circumstances, will you consider him to be an employee of PRDA, PNRD, or only DRDA?
Now,
That is the query which perhaps has not been very strongly put by the respondents. Their claim is that since he has started on deputation, he has started working from DRDA, and only upon his absorption, he was absorbed into PNRD, his seniority will be counted from the date of absorption in PNRD because these services were earlier rendered under DRDA. But his order of deputation is deputed to PNRD, not to DRDA.
yes, not to DRDA, but admittedly, my lord, he was deputed, my lord, to PNRD. He was,
No. He was deputed to, because we go by your order only.
yes,
The order of deputation is clear that he is sent to PNRD.
yes,
Where is that order, Mr. Dr.?
46 days.
46.
case 46.
Yes, 46. If you read 46,
Yes.
you find, is it 46? Okay. At the disposal of PNRD.
Yes, that is true. Lordship will kindly come down to the conditions, including the following conditions.
Yes.
My lord, the condition number 3. I will
Yes.
be relying only on this one. Condition number 3, I will be specific, my lord, limiting my argument only to this one. Liabilities for payment of leave salary and pension contribution will be borne by the foreign employer, that is DRDA. Lordship will kindly mark this. This is the term.
This deputation was at whose request?
The deputation, my lord, intra-department.
Somebody will have to make a
Yes.
request.
Yes,
Who made that request?
my lord, that the PNRD department.
Where is that?
Sir, from irrigation, my lord, he was deputed, my lord, to the
That's
PNRD.
what I'm saying.
Yes.
So, who applied for that deputation?
That is, my
Who
lord,
sought for the deputation?
I couldn't find out from the pleadings, my lord.
It is not in the pleading.
Yes,
It will be there in the
There
record.
was no request, man. There was no request from the PNRD department, man.
Then, on his own,
From their department, he was appointed, man.
whose department?
His parent department, man. Irrigation department, his department. Well, because in our file, there is no such letter, man.
Yeah, but without the consent of the employee, he can't be sent on deputation.
yes.
My lord, in the scheme, my lord, the DRDA scheme, there were some such requirements, maybe from DRDA, some maybe.
That is what we want to find out.
Yes, my lord. DRDA.
If it is
now,
from DRDA, it will be
dissolved, my
available
lord.
with
It's the
you.
year 2016, my lord.
Huh?
DRDA is no longer available, my lord.
Records will be available.
I have to ask the authority, my lord.
You have to,
Yes, ma'am.
because if it is your case that he was actually sent to from the arguments which you are trying to make is that this deputation was actually sought for by DRD, not by PNRD.
It's my.
But because DRDA, PNRD because he's a government servant
My lord.
and he has to be, is sent to on deputation to another government department.
Yes.
Therefore, the order is issued by the PNRD or he's placed at the disposal of PNRD, but posted in DRD.
Posted in DRDA. Now, for the time, that the timeline for which he had worked in DRDA, this condition number 3 is specific and clear.
This is about pay, pension, whatever leave salary, money issue we are not concerned with.
No, that's what my
We are concerned with who borrowed his services.
that is true. But at the end of the day, my lord, in my respectful submission, subject to lordship corrections, lordship.
You want to say the liability for leave salary, pension will be borne out. All right.
Now, there has to be, my lord, a continuity in service. What is the tenor, the whole tenor of the case?
That is precisely what I'm asking you.
Yes.
For that, for you, for the court to come to a finding regarding the continuity, we
Right.
must know who borrowed his services.
Yeah, but that perhaps, my lord, my learned colleague will be.
Unless, because from the document, from this 46, if you read 46,
Yes,
it can only mean that he's placed at the disposal of PNRD.
yes,
Meaning thereby the borrowing department is PNRD.
PNRD.
He may be posted anywhere under PNRD, equivalent posting. Payment may be made by any authority, but the borrowing department is the PNRD. Unless you have records to show that to the contrary.
That is true, my lord. That is one aspect of the matter. But I will be limiting my argument.
No,
Yes,
your arguments to be considered.
my lord.
that-
Once my lord is, my lord, satisfied with the record.
If his borrowing department is PNRD, all these arguments are irrelevant.
Then, my lord, my argument will be,
Your argument is that in terms of condition 3,
Yeah.
all liabilities are on the DRDA.
DRDA, that is one. Secondly, my lord, irrespective of whatever has happened, a person works for a specified period of time in a specified scheme. Deputation, my lord, regularization, absorption, irrespective of what. He works for a particular period in a scheme. Whether that period of service can be counted after his absorption, after he is absorbed. The answer is no. I will rely on yes. This is 2002-10 SCC 656. But I have given a copy. My lord, is a
2000?
2002-10 SCC 656. I will be relying on the Manupatra version. I have given a copy, my lord, mailed a copy. It's a sole decision of
version निकाली
656, sir.
अब नोट कर लीजिए
2002-10 SCC 656. Dhyan Singh and
656.
yes,
Paragraph.
my lord, there is only one paragraph.
All right.
It is my lord Dhyan Singh versus
One minute, just
my
one.
lord,
Yes.
lordship has got that decision.
I don't need to. Yes.
My lord, I am reading it, my lord. This appeal and the writ petition raise the common question as to whether the services rendered as an adult education supervisor under a non-formal education scheme evolved by the state of Haryana can be counted for the purpose of granting pensionary benefits as well as for the purpose of fixation of his pay when such an employee is recruited to a regular post under the state government, either with or without break of service. Needless to mention that the appellants, after having served for a number of years under the Rural Education Literacy Project, State Adult Education Program scheme itself, under which they had been discharging their duties, stood abolished, and consequently, the appellants ceased to be the employees. They had approached this court in a writ petition which was registered as so-and-so, seeking a mandamus to the state government for their absorption in regular cadre of the state government. In the state case, the council appearing for the state of Haryana fairly submitted that the government is prepared to absorb the applicants in the state service as and when vacancies in the cadre of social studies teachers and masters are available. And on the basis of the state statement made by the council appearing for the state of Haryana, the writ petition was disposed of with the direction that the state government should utilize the past experience of these persons by absorbing them suitable and when vacancies would occur in the post as already stated. Pursuant to the said direction of this court, the appellants were recruited to the post of teachers on different dates in the year 1993, and they were taken as fresh recruits. Their salary had been fixed at the initial stage of the scale of pay for the post in question. The appellants therefore approached the High Court seeking relief that their scale of pay should be fixed up, taking the past services into account, and that their past services rendered under the scheme should also be taken into account for the purpose of deciding their pension. The High Court, relying upon the circular issued by the government on so-and-so, came to the conclusion that no part of the services rendered by the appellants as supervisors in the adult education scheme can be considered either for the purpose of determining the initial amount of salary which they would get on their regular absorption, nor can the same be taken into account for deciding the pensionary benefits, ultimately which the appellants would receive on superannuation from the regular services. It is this judgment of the High Court which is the subject matter of challenge in these appeals. So-and-so, appearing for the appellants, strenuously contended that by judgment of this court, the appellants having been given the regular pay scale while continuing as an adult education supervisor under the scheme on the basis of which they were discharging the full-time duties, there is no rationale to deny the relief sought for by the appellants in the writ petition. So-and-so has also contended that the High Court was totally in error by coming to the conclusion that the appellant had rendered as part-time supervisors, which is belied by the earlier decision of this court. He further contended that since the government rules and regulations, the temporary employees, the ad hoc employees, and the work search employees are entitled to count their services for the purpose of granting the pensionary benefits, it would not be fair to discriminate this group of employees, though undoubtedly they had served the period under a particular scheme. Having considered the two contentions made and having applied our mind to the rules and regulations that was shown to us, we are not in a position to accept either of the conditions raised by so-and-so. The continuance of the engagement of the appellants under the specific scheme cannot be held to be an employment under the establishment of the government.
This is the query raised by the court. Here is a case where they were working for some scheme.
Yeah.
Then subsequently it was abolished. Then they were absorbed in the state government. Now whether that earlier services can be counted.
I'm coming, Manoj.
Ah.
But the continuance of so-and-so under specific scheme cannot be held to be an employment under any establishment of the government. Such schemes are taken up for certain contingencies when money for the same is provided either by the central government or at times by some foreign countries. But the employment under such scheme not being a part of the formal cadre of the state government it is difficult to hold that the period for which an employee rendered service under such scheme can be counted either for the purposes of deciding their pensionary benefits or even for fixing of their salary in the scale of pay once they are regularly absorbed. The judgment of this court pursuant to which the appellants were absorbed as against regular posts in the government itself would indicate that the court had taken a compassionate view and not on the rights which flowed from the past services rendered by the appellants under the scheme in question. And that also under the concession of the council appearing for the state government. We have not been shown any rules or regulations of the state which confers pensionary benefits to such services rendered by the appellants. In this view of the matter, it is ultimately, my lord, it was dismissed.
Okay,
So I am limiting my argument only to this aspect.
you are limiting, but before that, I have asked a very pointed and limited question to which I am not getting the answers.
That perhaps my colleague will. be
No,
in a
that
better-
the judgment itself reflects the query I am asking. These are the people who were appointed to a scheme. They were not government employees. They were not deputed. They were not borrowed. They were working. Then these schemes got abolished and subsequently now they are being absorbed. Whether their past services will count. No.
Here also, my lord, it was the
No,
scheme.
here,
That scheme
no,
got
no, no,
abolished.
here he was a government servant. He was working in the irrigation department. He was deputed. To whom? That is why I keep on referring to page 46. At the disposal of PNRD, not at the disposal of DRDA.
True, admitted. But for that period, my lord, for that
This
particular
is not a
period,
proposition for that, I'm sorry. This cannot be a proposition for what you are trying to argue. This is a proposition where the person's initial entry or service was under a non-government body or some scheme. There, of course, the services rendered will not be counted on subsequent absorption.
that is true.
Then
But
if it
here,
is
my
true,
lord,
then how is it applicable?
no, my lord, I'm going by page 46.
Your
because-
case is that notwithstanding he being borrowed by a government department, it was placed at the disposal of DRDA.
DRDA. So
Therefore,
for
that service
period-
will not count.
Yes, for that period, since DRDA
All
was the
right, all
sole
right.
authority.
We accept your argument.
yes.
Yes. Anything more?
Yes.
That's all. But Mr. Dotto, you'll have to give us the records with regard to the who borrowed his services,
My lord.
whether he applied or PNRD asked for it or
Petitioners pleadings are also silent in this regard, my lord. I've checked my.
yes. Yes, Mr. Tiwari. Your only reply is
My
with
lord,
regard.
I have patiently heard both my colleagues, attentively heard them.
This must be one of the rare occasions where you have displayed your patience.
Now, my lord, at the very outset, one can't compare apple with oranges. And all along the efforts are being made to compare apple with oranges. Here is a case, and it has rightly fallen from your lordship. Here is a case that the petitioner was born as a government servant. He was in the Department of Irrigation. He was regularized in Department of Irrigation when he was serving in a substantive capacity on a regular post as a government servant in the irrigation department. He was sent on deputation. Now, my lord, one is sent on deputation. It's a fundamental principle that one cannot be sent on deputation unless and until borrowing department desires it, lending department agrees to it. There has to be consensus and a addendum between the borrowing department and the lending department, and the employee concerned agrees to go on deputation. So, my lord, these three factors come together. Borrowing department desires services, lending department is willing to let go of the employees, and the employee accepts it and gives his consent. Then only, my lord, one goes on deputation. So, my lord, the very language of deputation itself is clear. He was sent on deputation to the Panchayat and Rural Development Department. Now, my lord, it is the department which borrowed the services, rightly fallen from your lordship. Department he is sent to, it is the department which sends him on deputation to DRDA. This is first part. Now, secondly, my lord, what is to be borne in mind is, yes, it is correct. The rules are silent on absorption. It is precisely for the reason that the rules are silent that in this very case, there was a cabinet decision. In none of those cases, judgments that have been cited, there was a cabinet decision. Here the cabinet decided. Now, my lord, what is the agenda before the cabinet? The very agenda before the cabinet discusses the entire background of the petitioner. That he was regularly appointed in Department of Irrigation, he was Agriculture Extension Officer, he was sent on deputation. And my lord, not only when he was sent on deputation, he joined the Department of Panchayat and Rural Development. After some time, it was Panchayat and Rural Development Department which wrote a letter to Department of Irrigation seeking its consent for absorption. Let us not ignore those facts. That shows the very intention of the Department of Panchayat and Rural Development. So, my lord, the agenda item was all clear. Entire background of the petition was discussed. That is number one. And number two, my lord, there were more than one post where the petitioner could be absorbed. I asked myself as to what prevailed in the mind of the department to absorb him only against a particular post. What was that post? Deputy Director Training. And fact of the matter is, the post was lying vacant since 1/3/99. It's a relevant factor. Why against that very particular post only? That was the reason for which he was,
Deputy Director Training were under PNRD
yes,
or
under
under,
PRD.
or under DRDA.
My lord, it is not under DRDA. It's a regular post. This has been discussed. A regular post in Panchayat and Rural Development Department lying vacant since 1/3/99. So, my lord, these factors are very relevant. On 25/9/2001, Annexure 5, page 55 below in my list of dates. 25/9/2001 is a communication from PNRD department to Irrigation Department seeking NOC for permanent absorption of the petitioner as Senior Block Development Officer under PNRD department. At least there was a thought process as early as in 2001. It is a different matter that subsequently there was a war phase and the PNRD department decided nothing doing, he should be repatriated. But that shows the intention as early as in 2001 to absorb him as Senior Block Development Officer under PNRD department.
No,
If that was-
facts, more or less.
Yes,
it
and
is clear.
thereafter, my lord, what happens? So first of
We
all,
want you to, we want your reply in respect of the judgments relied by the,
judgments, my lord, these are all the judgments. Even if we see the our SI Ruplal case, in SI Ruplal is BSF, central government, to Delhi police. Even other judgments, my lord, it is one autonomous organization versus another autonomous
so
organization.
what about the Indu Shekhar?
My lord, even in Hindu Shekhar, the organizations are entirely two different organizations. Here is a case wherein all along petitioner is a government servant of Assam.
No.
He is an employee of the government of Assam.
In Indu Shekhar, if you read the relevant paragraphs, there, the ratio of Ruplal was
But below
sought to be clarified, if that is the right word.
Sought to be clarified because Hindu Shekhar below, I believe, is of the two-judge bench. Hindu Shekhar is of two-judge bench. Ruplal is three judges. And Tara 19 Ruplal reiterates the principle of law laid down in Makashi and Joginder Singh. And Ruplal, three judges, which is a full bench of the Supreme Court. Be that as it may, my lord, I believe so far as Hindu Shekhar is concerned, even in Hindu Shekhar,
But both are
Unlike-
binding on us.
my lord,
Both are binding on us.
my lord will go by a larger bench, which is SI Ruplal, three-judge bench. Unlike the Hindu Shekhar, but even Hindu Shekhar is distinguishable very clearly. My lord, if I remember correctly, I was listening to my esteemed colleague when he was reading from Hindu Shekhar. Even in Hindu Shekhar, unlike the present petitioner, the facts are different. The present petitioner, my lord, all along was the government servant of Assam. Department of Irrigation to begin with. There is no change in his status. It is not that, my lord, he came from the central government. It is not that he belonged to some autonomous organization. That is not the case. He was in Department of Irrigation as Agriculture
No,
Extension Officer.
I would request you to go through Hindu Shekhar. And there are 47 days down the criteria, which much as I would like to, but it appears that These para 47 principles have been laid down by the apex court for universal,
My lord,
as a universal proposition.
I'll go through Hindu Shekhar in extensive, my lord, because I don't have the, I'm sorry, I don't have the judgment with me. But my lord, I would distinguish Hindu Shekhar primarily because, my lord, because in the case of Hindu
No,
Shekhar, there were rules.
factually, I agree with you.
In the case of Hindu Shekhar, there were rules.
No, but you'll have to read para 46, 47 of Hindu Shekhar, along with other
My
paragraphs.
lord, can I?
No, that's okay. Take your time.
But my lord, whatever I've heard, my lord, on that basis, my lord, I'll try to make a distinction. So
No,
for
no,
us-
you make a distinction after going through the judgment properly.
Very well. If that be the
That is-
case, I'll
that
go
is-
through.
Because
But
we need to, because Ruplal has been referred here,
Very
and it has been held in no uncertain terms that the ultra-virus held in Ruplal is only with regard to a portion of that OM.
Very well. Even then, in that case, Joginder and Makashi are also, anyway, I'll go through. I'll go through Hindu Shekhar in toto, my lord, to the satisfaction of my lord, and I'll satisfy myself also in the process. I'll go through Hindu Shekhar, but it's not possible. Either will not become in the second half, or will not it goes to some other date,
All right.
because
We'll have it on some other date, no problem on that. But we are clear on the facts, which
Yes.
they have not been able to distinguish that the facts are different.
yes,
Had it not been for Hindu Shekhar, perhaps we could have relied on Ruplal.
yes.
But Hindu Shekhar has categorically held that Ruplal is not an authority for all except for holding that OM to be ultra-virus to that extent.
I'll my lord, go through in total. I'll read Hindu Shekhar in total.
Prima facie,
And I will also go through Joginder as well as Makashi. Another judgment.
prima facie, even without Ruplal also,
Yes,
on the facts itself, you have an arguable case.
because that is why we not the cabinet decision. We have to see that. And the language of the cabinet decision. All those factors will come into play. And cabinet decision was because there were no rules. That is why the cabinet decision. And also the post remaining vacant since 1399. The communications between Milord,
In the proposal, there was no mention about your seniority.
the proposal
Before the
spoke
cabinet.
about, Milord, we have to read them between the lines. Specifically doesn't talk about the seniority, but when the discussions started, in the very beginning, the stand of the Panchayat and Rural Development Department was that I have to be treated to be absorbed with the department itself. Emphasis was of the department. And that is why initially, in the initial communication, all along the Panchayat and Rural Development Department took a ground that since the post was lying vacant, it has to be treated against that very particular post. For the purpose of continuity.
Okay.
It is much later that Commissioner and Secretary will not took a sudden turn in a different direction. But prior to that, even the Commissioner and Secretary was consistent with this very particular stand. But in any case, I'll go through the Hindu Shekhar in toto and I'll find out the distinguishing features. And I will also go through other judgments of the Supreme Court on the subject.
Please do.
So, could it be then, 28, 28, 28th of September, 28.
Yes, do it.
Very well.
My
20.
lord, point 5 of the proposal, my lord, that was also maybe noted, my lord. That proposal, point 5 may be noted, my lord.
0.5,
Yes, my lord.
page number.
Cabinet, page number 68B, my lord. That is very relevant for this point, my lord.
You have not understood the.
Yes, my lord. But he
You keep referring to
accepted,
the same issues, you see,
my lord. He
unless you are
accepted
able to
this,
distinguish with page 46.
Right.
Page 46 is the order of the department sending him, agreeing to the proposal for borrowing him. And he has been lent to the government department.
my lord.
Where he is posted under what scheme will not take away his status as a government servant. 28. All right.
My
For
lord.
further hearing on 28.
My lord. Highly obliged.
I take down the names of the councils, all council. Yes. Where is your opponent?
Morning, Malad, he told me that he perhaps missed the item today, Malad. I don't know.
How can you miss it? We had fixed it.
Yes, Malad, he told me that. 18.
Lordship, my senior is in legs in another court.
All right, we'll try in the second half.
My lord.
Yes. Yes.
This matter is relating to residential dispute of the petitioner who is serving as Anganwadi worker.
My lord,
And in
here
the last occasion,
we have received the partial instructions, my lord. My lord, we'll need to file an affidavit in this regard. I'm just placing it before your lordship. My lord, here my instruction says that the writ petitioner is not from that particular area. Number one, the respondent number, the private respondent is from that area, my lord. So that is the all about, and there was an inquiry to that effect by the authorities in the child and
We have
woman.
no difficulty asking you to file your affidavit.
I will
But-
file an affidavit, my lord.
Yes, but give us an outer limit.
My lord, in next 10 days, it will be on record, my lord.
But your affidavit must include the documents
Yes, my lord.
on the basis of which the inquiry was
My lord, has to be
conducted.
my lord. Otherwise, my lord,
Mr. R. Dhor, learned government advocate, prays for and is granted 2 weeks' time to file the affidavit as it is submitted that is received instructions to show that the petitioner is not a resident. That the petitioner is.
and
not a
moreover,
resident.
she is not from ST community, and that is an 100% ST.
Petitioner is not a permanent resident of the area where the Anganwadi center is situated, and that apart, that area, that center was, the recruitment to the center was to be made from 100% ST community, and the petitioner does not belong to that community. Mr. Dhor will file the affidavit along with all relevant
Document. I will.
papers necessary. Mr. Hazarika for the petitioner, Mr. Soronia for private respondent. List after 2 weeks.
May I please, your lordship? May the matter may kindly be passed over for a time.
Adjourn for the day. Some other day. it will come. Yes. Yes. This will require hearing. You are relying on some Supreme Court judgment. But state government judgments are there. I'm sorry, state was relying on some other judgment. You have relied on which judgment? This Pandey?
Prem Singh, yeah.
Huh?
Prem Singh, yeah. Prem Singh.
Prem Singh.
Relevant paragraph is page 73.
Same thing. Not here. I think that's not good. There is a writ appeal judgment also.
2019,
No, there is a writ appeal judgment of this court, division bench judgment of this court.
it is a- no, I am not referring, no. That was apart by,
You are not referring, but it is applicable in your case.
not relevant, not,
Why?
my case is different.
Your husband was master roll.
Yes, master role, he was a.
Then he expired,
He was a, workers employee
work charge, then
in a sanction vacant post. He was on.
maybe, then
Then he died while in service,
without being regularized.
without being formally regulated.
That is the judgment about, have you gone through this writ appeal judgment?
But in their case, they are, those persons were not in sanction post.
They were master rolls.
They are master role. But my husband was engaged in a sanction vacant post.
Maybe, but not regularized.
May not be regular. Yes, ma'am. not
Ah.
regular.
Yes, who's for the respondent?
This matter, my friend P. Naik is handling.
Hmm.
He's in court number 10 on leg.
Who's referring to this judgment? You are referring to this judgment also? Dhanji Bhai? Gujarat judgment?
Supreme Court judgment. Yes. It is Prem Singh,
Okay. Yes.
2019 air 49, 4019.
My lord, before proceeding further, my lord, just I want to bring one thing, my lord. This is a matter of BTC area,
Hmm?
Pokrajha.
Hmm?
BTC.
Hmm.
And it's a PWD is a transfer subject for the BTC, my lord.
You call to the council?
So their name is also not shown in the cause list. I don't know whether they were served a copy or not, my lord. So some response has to come from them.
First, you at least call the council, inform the council for BTC use there.
My lord, no, their name is not in the cause list. That's what I'm informing, my lord. I can always inform, my lord.
Yes, you inform them, ask them to appear in the court. All right, we'll take it up after a while. Let the judgment come.
Judgment I have annexed.
After a while. It was judgment. Yes.
Before my learned friend starts, I just wanted to point out one aspect. If your lordship will kindly take up WPC number 4570.
Yes.
Your lordship comes to the prayer portion at page 28.
20,
28.
28.
The first prayer, if your lordship sees, is a challenge to the DPC
Hmm.
decision taken by the Departmental Promotion Committee in the meeting dated 28/3/22. There are two aspects I wanted to point out.
Hmm.
Firstly, my lord, after the writ petition was filed, this has already been given effect to, and he has been promoted as the private respondent, has been promoted not only as chief engineer, he has been further promoted as secretary. And both these are things are
Your client.
my client.
Yes.
So both these things are not under challenge. So that is one thing I wanted to point out.
Hmm.
The item number 5, the first item, that is WBC 5623 of 2021. In that, my lord, an action by the respondents in promoting the private respondent to the post of additional chief engineer is under challenge. And what my learned friend has now pointed out to your lordship in WPC 4570 of 2022, it is basically a consequential order which has been challenged by way of that writ. So on 5623, your lordships may kindly come to the order.
So you are challenging the promotion of Mr. Chaudhary's client to the post of additional chief as it then
Additional-
was.
At that time, yes. Additional,
Subsequently, DPC was held and he is promoted to the
he
post
was
of chief
further
engineer.
promoted to the post of chief engineer, and for
Hmm.
which, my lord, this 4570 was instituted.
So perhaps that aspect also you need to challenge it.
So far as, my lord, that is 4570 is basically a consequential action on my part.
Maybe, but
He-
now there is a specific order and he is taken over as a chief engineer.
He has been further promoted as secretary,
No,
next level.
he
So-
was promoted as chief engineer, and that order is under challenge in 4570.
No, only recommendation is.
The recommendation was challenged in 4570. Now, if the recommendation goes, then challenging his promotion order is basically a consequential action
But if he's been subsequently promoted further,
to the post of secretary. Well, on that, I have no grievance at this moment of time.
how?
At this moment of time, my lord, I have no grievance.
You
on
are
that.
aggrieved by his promotion to the post of chief engineer.
Basically additional chief engineer. And if the additional promotion to the post of additional chief engineer goes, all these subsequent actions will automatically fall. For the sake of clarity, my lord, the 4570 was instituted so that DPC recommendation can be brought under challenge.
All right.
Now, the entire thing revolves around a very short point. I'll show to your lordship the DPC minutes, and by which, my lord, my case was not considered and his case was put forth as the candidate, and he was selected as the candidate for the post of additional chief engineer. The basic case of the respondent department was that merely because I earned an accelerated promotion during my past career, therefore, by operation of the office memorandum clause 4 of that 2016 office memorandum, by operation of clause 4 of that 38/2016 office memorandum, I will not be entitled to promotion. Your lordship will kindly see the minutes of the DPC.
Where is that OM? Is it here?
The OM, page 63 is the, 62 is the OM. Page 62, annexure 17. And the clause 4, which the respondents had relied on, that is at page 64.
OM.
Yes.
Yes.
Page 64, your lordship may kindly come to clause 4. If an occasion arises during the promotion process in which stipulated percentage in respect of reserved category is met, but in the gradation list, senior list, there are candidates of reserved category who on merit is entitled to promotion, her case shall be considered for promotion on merit if such candidate has not gained seniority by way of any accelerated promotion earlier. So merely because I earned accelerated promotion in my career in the past, so they relied on this clause, and therefore they say in the minutes that the respondent will stand a better chance.
Who belongs to the reserve category?
I belong to the reserved category.
You belong to
I
the.
belong to the reserved
So
category.
in terms of this clause,
They say that since I earned accelerated promotion in the
no, no,
past,
let us understand the clause first.
Yes.
Clause says the percentage in that reserve category, if it is met,
yes. But in
but
the gradation
you are
list,
otherwise on merit.
on merit.
And if you did not gain seniority by way of accelerated promotion earlier,
Then
only then you'll be
yes.
considered.
But that means
So notwithstanding you coming in merit
yes,
is not a ground for consideration.
no. My merit will not come as a ground for consideration only because
You had gained accelerated promotion.
accelerated. That is the only ground.
So it is essentially saying that if the quota is met,
Yes,
that's the end of it.
that's the end of it. Notwithstanding that I qualify on merit. So the basic principle that operated in their mind is that if you had earned an accelerated promotion in the past, so you have already gained one, or at least in one occasion, you have gained some advantage. So you will not be given a second advantage or a subsequent advantage in the promoted post. Now, this, as your lordship knows, my lord, there were cases before this honorable court where this particular clause failed for consideration vis-a-vis the previous office memorandum of 2002, which say that accelerated promotion cannot be done away with, so to say. Now, these determination by the honorable court, by a single bench of this honorable court, also went taken into appeal before a division bench, and the division bench judgment has come. And I, as far as my understanding goes, my lord, the position which the 2002 office memorandum had postulated, that regardless of whether or not you have earned accelerated promotion, the recourse to that still remains open, my lord, that position is still holding the field. Now, before I come to that judgment or the judgment of the single bench, my lord, I'll just place before your lordship the factual progression of the case. Now, the respondent and I, we were promoted, we were appointed through a combined selection process. And then in that selection process, I was the select list that had come in the beginning. I was at serial number 10 and the private respondent was at serial number 6. That is the admitted position. And on that, my lord, the private respondent also seeks to say that since at the beginning the position of seniority was, he was in the seniority above me, so that benefit should also flow, continuously flow to him.
Just to interrupt. In this writ petition, what is your challenge?
In this writ petition, my challenge is to the DPC notification. Your lordship will kindly come to page
On
30.
what are the grounds of challenge?
Now, the grounds of challenge are that this office memorandum dated 16, clause 4, it does not prohibit or inhibit the previous office memorandum of 2002. The previous office memorandum of 2002, your lordship will find at page 60. My ground is that it does not inhibit the previous office memorandum of 2002, and therefore the reliance on clause 4. Your lordship will kindly come to page 60.
Yes. What does it say?
This is the 2012 March 2002 office memorandum. Consequent upon amendment of Article 16(4)(a) of the Constitution of India by the Constitution 85th Amendment of so and so, it has been decided that following principles of fixation of seniority of reserved candidates vis-a-vis general candidates in promotional posts shall be followed. Scheduled caste, scheduled tribe government servants shall, on their promotion by virtue of rule of reservation roster, be entitled to consequential seniority also. And the above decision shall be effective from 17th June 1995. On the basis of the revised seniority, consequential benefits like promotion, pay, pension, etc., shall be allowed to the concerned scheduled caste, scheduled tribe government servants without arrears by applying principles of no work, no pay. For this purpose, senior scheduled caste, scheduled tribe government servants may be granted promotion with effect from the date of promotion of their immediate junior, general, other backward classes government servants. Such promotion of scheduled caste, scheduled tribe government servant may be given with the approval of the appointing authority of the post to which the government servant is to be promoted at each level after following normal procedure of Departmental Selection Committee and with the approval of Assam Public Service Commission. Except seniority, other consequential benefits like promotion, pay, etc., including retirement benefits in respect of those who have already retired, allowed to general other backward classes government servant by virtue of implementation of office memorandum number so and so dated so and so, or in pursuance of the direction of the Assam Administrative Tribunal Court should be protected as personal to them. The instructions contained in these departments OM dated so and so stand withdrawn with effect from 12/6/96 itself, and the seniority government servant determined in the light of the office memorandum dated so and so shall be revised as if that office memorandum was never issued. The main thrust on this office memorandum was on the proposition that the reserved category candidates will also be entitled to accelerated promotion in the promoted post. If I have earned an accelerated promotion in the leader cadre, in the promotional post also, I'll be further entitled to promotion regardless of the fact that whether it was not. That is basically, my lord, there is a rule which we commonly known as catch-up rule, that the general category candidate, if I supersede the general category candidate in the promotional post, after his promotion, he will stand senior. So that was the catch-up rule as we understand. But this office memorandum had brought in the concept of accelerated promotion in a sense that regardless of my the general category candidate coming to the promotional post, I will still retain my seniority. Now, this was somewhat attempted to be diluted by operation of that clause 4 of 2016 office memorandum. Now, the purport of the judgment of two judgments of this, the single bench and the honorable division bench of this honorable court. Well, this position, as in the office memorandum number 59 of 2002, that is not disturbed. And therefore,
No, why do you say that this clause 4 does not essentially
inhibit?
unsettle the position in this 2002?
Yes, because clause 4 wanted to bring a condition that if I have earned accelerated promotion in the past, then regardless of my merit, I will not be entitled to further promotion. Provided the vacancy position is met, the roster vacancy is met. So that brings a, because otherwise, if I can be as the general proposition goes, if a reserved category candidate secures.
What you are saying essentially is this clause 4 will be applicable for those reserved category candidates who are below in the seniority list. Is that what you're saying?
No. What I want to say is that the benefit that this 2002 office memorandum wanted to percolate down was somewhat restricted by that office memorandum dated 2016 clause 4, because it said that regardless of the fact if I march above the general category
Right,
candidates
but
on account of my merit.
You opened your arguments to say that effectively it did not alter.
No, yes, I say that it did not alter, but they interpreted it in a way that this clause will inhibit the benefit of 2002. This will inhibit the benefit of 2002 office memorandum.
Clause 4 of 2016 says
Yes,
that if the quota is filled up.
yes, suppose now the position is this, my lord, as I understand. If a reserved category candidate gets selected because of his merit, then regardless of the position, whether or not he earned accelerated promotion in the past, he will be given the chance. But this particular clause said that if you earned accelerated promotion in the past, then provided the quota is met, quota of your particular category is met, you will not be able to qualify on merit.
So this alters the position in 2002.
Yes, this inhibits the position in 2002, and therefore, my lord, challenging this particular office memorandum and the similar other, there was another office memorandum, my lord. The challenge was made before this honorable court. Now, the eventual decision that has come, if your lordship will kindly find that. Now, the first decision that came, it was in the case of Bhagavan Patar and the analogous matters, my lord. And the eventual decision of the honorable court has been that this will not inhibit the effect of 2002. Because 2002 is still holding the field. Therefore, there was a subsequent challenge before the division, but the position remains same. So, if the position as on date remains same, that 2002 office memorandum has to be given its effect, then the eventual conclusion that the DPC had taken in my case, that merely because I earned accelerated promotion and therefore I should not be given the promotion in the post.
What was the finding of the single bench?
No, I am looking.
So you can just tell us, we'll go through the order specifically.
Yes, my lord, it is
Tell us.
enclosed in the reply, my lord. My lord, I'll just read that out.
Page number?
My lord, it will be from page number 297.
Yes.
297, and your lordship will find the eventual conclusion in paragraph, it will be paragraph 7, page 335.
Three 35.
It will be
Yes.
internal page 66.
Yes.
Paragraph 7, the aforesaid determinations can be summarized in the following manner. The policy of the state in providing reservation in promotion with consequential seniority is discernible from section 5 of the 78 Act, read with OM dated 12/3/2002. The office memorandum dated 12/3.
What is the 78 Act? What is the 78 Act?
That is the reservation of SC, Assam State Reservation of Utah and Shield Tribe in
State Act.
State Act. The office memorandum dated 12th March 2002 shall hold the field till such policy is expressly repealed by the state. OM dated 3/6/2006 is notified laying procedure for collection of quantifiable data on backwardness and inadequacy of representation in and determining efficiency in administration while giving effect to such policy of providing reservation. Given the dicta of Jarnail Singh, the OM dated 3/8/2016 cannot sustain so far the same relates to collection of data on backwardness. The determination of cadre as a unit for collection of quantifiable data as laid down in OM dated 3/8/2016 conforms to the mandate of Jarnail Singh and M. Nagraj, and therefore the same is upheld. The procedure as laid down for determining efficiency in administration not being arbitrary and not being based on any extraneous consideration, the same is upheld. Now, apart from the other two, three points, my lord, what has been modified by the honorable division bench, I'll read out that judgment to your lordship. Except for holding that 12/3, the validity of 12/3/2002 to be holding the field, the honorable division bench has only modified the aspect of collection of quantifiable data and on backwardness and inadequacy of representation.
So 2016 has been held to be bad.
So far as it offends, so far as it tried to inhibit 2002.
Where is it specified? Clause 4
Yes.
says it is bad, cannot sustain. so far as it relates to collection of data on backwardness.
Collection of data on backwardness, efficiency on inadequacy of representation and efficiency in administration. The 2016 office memorandum has been upheld, said to be, it has to be said to be valid for these three purposes only. But so far as it comes in conflict with 2002, so the declaration is that the 2002 office memorandum still holds the field. So
Where is the
that is at clause
clause 2?
Clause 2. The office memorandum dated 12/3/2002 shall hold the field till such policy is expressly repealed by the state. And this has been so said, reading it in the context of the section 5 of the Act, 78 Act. Now, this judgment went to appeal, and the appellate judgment, if your lordship will kindly take up. It is your. My lord, I have supplied a copy. Your lordship may kindly come to paragraph 20 at page 21 of this division bench judgment. Page 21 of the judgment, paragraph 20.
Yes.
As regards clause 4 of the office memorandum dated 3/8/2016, it is the submission of Mr. K. Chaudhary, learned senior counsel, that as consequential seniority itself has been withdrawn by the state authority, no further question remains on any claim of the reserved category candidates for consideration on merit pursuant to their consequential seniority. Now, thereafter the submissions are recorded, your lordship can skip over and your lordship can kindly come to paragraph 29 at page 26. With
Yes.
regard to the contention raised by Mr. Chaudhary. With regard to the contention raised by Mr. Chaudhary, learned senior counsel so for the appellant, that the provision for consequential seniority having been provided by the Constitution 85th Amendment, which itself is an enabling provision, it is always the discretion of the state authorities which provides for such consequential seniority to also withdraw the provision of the consequential seniority. It is taken note that an enabling provision in a statute is understood to be a provision which does not provide for any specific provision, but the statutory provision enables the executive to provide for such provision if otherwise advised or justified under the law, meaning thereby that it is a discretion vested on the executive authority through delegation to either provide for or not to provide for such provision. The only compelling circumstance that remains would be that once in exercise of the enabling provision, if a particular provision is provided for till such provision remains in place, it would be binding for all as regards the requirement to implement such provision. But at the same time, in the same manner in which a discretion was vested in the executive authorities to provide for such provision, if so advised and justified under law, equally it would also be open for state authorities to withdraw such provision as per their own discretion, again subject to if justified in the circumstance as well as under law. From such point of view, we are in agreement with Mr. So that office memorandum dated 29/12/2014 could have also withdrawn the benefit of consequential seniority meted to the reserved category candidate by the earlier office memorandum dated 12/3/2002. But at the same time, although the enabling provision enables the state authority to withdraw such benefit, but what would further have to be examined as to whether the office memorandum dated 29/12/14 in fact withdraws the benefit of consequential seniority meted by the office memorandum dated 12/3/2002.
This is another memorandum.
There was another memorandum in between. To substantiate the contention that office memorandum dated 29/12/2014 had in fact withdrawn the consequential seniority earlier given by office memorandum dated so and so, Mr. Chaudhary relies upon the clauses 111 and 14 of the office memorandum dated so and so. A reading of clause 111 of the office memorandum makes it discernible that the rosters are in aid to determine the entitlement of different categories with regard to the quota reserved for them, but they are not entitled to determine the seniority. In other words, we are required to interpret the meaning of the word they appearing in clause 111. The expression they refers to the earlier sentences in clause 111, that is that the rosters are in aid to determine the entitlement of different categories. In other words, the expression they refers to the rosters. The first paragraph of the OM dated 29/12/2014 provides that the office memorandum had been issued consequent upon the amendment to the Act of 1978, that is the State Act, and the acceptance of the recommendation of the one-man commission constituted by the Governor of Assam. We have taken note that the recommendations of the one-man commission referred in the OM dated so and so had in the meantime been held to be unacceptable as per the judgment of this court in Equality Forum. At this stage, we take note of the fact that there are two judgments available both in respect of petitions instituted by the Society Equality Forum. One such judgment is dated so and so, rendered in WPC number so and so, reported in 2016 1 GLT 710, and the other one dated 6/6/2022 in WPC 5005 2016 and 5026 2016. For clarity and convenience, we refer the judgment rendered in Equality Forum Supra, reported in 2016 1 GLT to be Equality Forum 1, and the judgment dated so and so in WPC so and so as Equality Forum 2. In other words, the purport of OM dated 29/12/2014 has to be understood that it was issued consequent upon the amendment of the Act of 1978. As noted above, the Assam Act 19 of 2012, the Act of 78 had been amended, by which Section 5A thereof had been introduced. It had also been taken note herein above that Section 5A of the Act provides for post-based roster for implementing reservation in promotion. As the office memorandum dated 29/12/14 had been issued consequent upon amendment by which Section 5A of the Act had been introduced, the word roster in clause 111 and the further provision that the roster do not intend to determine seniority would have to be understood in the context of Section 5A. All that Section 5A of the Act provides is that earlier the reservation in promotion was given effect by following the procedure of vacancies, but upon introduction of Section 5A, the same would be done by following the roster point in the roster scale. If a reservation in promotion is given effect or implemented based upon the roster point in the roster scale, there is always a possibility that a reserved category candidate may be promoted against the post, which may be a little higher up in the roster scale, as the said roster point may have fallen vacant. In this circumstance, the provision of clause 111 would have to be understood that the seniority referred therein related to roster would mean that if a reserved category candidate is promoted is against a roster point which would be a little higher in the roster scale in comparison to the other promotees who may be little lower in the roster scale, the same will not entail any seniority over the others who are also promoted in the same process, but perhaps placed a little lower in the roster scale. In other words, placement of a reserved category candidate in a given roster point, irrespective of the position, would not determine the seniority of such candidate, and the seniority would be determined otherwise under the law, depending on the manner and circumstance in which the promotion was given. Now, therefore, the next paragraph, your lordship can skip over paragraph 37.
Yes.
Accordingly, it would have to be concluded that a conjoint reading of clauses 111 and clause 14 of the office memorandum dated so and so would mean that the consequential seniority that was otherwise meted by the office memorandum dated 12/3/2002 had not been withdrawn. Now, thereafter, your lordship can come to page 31, paragraph 40. As I said earlier, my lord, the question of collection of quantifiable data on the question of inadequacy of representation and the
Yes.
the efficiency that has been done away with. If the determination of quantifiable data is for adequacy or inadequacy of representation of the reserved category candidates in a given cadre of a service in a particular department of the government, we are in agreement with the contentions raised by Mr. Dikedas so-and-so that it would be more prudent and appropriate to undertake such exercise through departmental promotion committee itself before embarking upon a promotion process for a given cadre. The same would be prudent inasmuch as the DPC will have all the data before it as to the cadre strength of the promoted cadre where the promotion is to be considered, and out of the total cadre strength, how many posts in the cadre are to be earmarked for the reserved category candidates, and out of the earmarked reserved category posts, how many posts are being occupied by the reserved category candidate. In other words, if the reserved category candidates are occupying all the posts earmarked for the reserved category candidates in a given cadre, it can be easily understood that in that given cadre, there is an adequacy of representation of the reserved category candidate. And in the event the number of reserved category candidates in the cadre is less than the number of posts earmarked for the reserved category candidate, it has to be understood that there is an inadequacy of representation in that given cadre. If the determination would be made in the above manner, we are of the view that it would be more appropriate and apposite for the DPC to make such determination. But again, such determination would have to be made before initiating the actual promotion process. Then your lordship can kindly come to page 33, paragraph 42. As a determination of the quantifiable data on inefficiency in administration across the board in respect of reserved category candidates would amount to a discrimination on account of race, which is prohibited under Article 15 of the Constitution of India. We also have to hold that the requirement of obtaining quantifiable data on effect of inefficiency in administration because of the reservation in promotion meted out to the reserved category candidates would also be a violation of Article 14 of India and hence impermissible. As the three contentions raised by Mr. So-and-so, counsel for the petitioner in so-and-so are answered in the above manner, indicated above, meaning thereby that as per the judgment of the Honorable Supreme Court, rendered in paragraph 36 in the journal saying 1, supra, there is no requirement of obtaining quantifiable data as regards backwardness, and as per judgment rendered by the Honorable Supreme Court in paragraphs 116 and 126 of B.K. Pavitra, quantifiable data on inefficiency in administration across the board in respect of the reserved category candidates cannot be obtained. And further, as the quantifiable data in respect of adequacy or inadequacy of the representation of the reserved category candidates can also be done at the later level of DPC in respect of the cadre for which the promotion process had been initiated. We are of the view that the prohibition imposed by paragraph 47 in the judgment dated 23/12/2015 in Equality Forum 1 supra would have to be understood in the manner indicated. In other words, there would not be any requirement of obtaining quantifiable data on backwardness and inefficiency in administration, and obtaining the data regarding adequacy or inadequacy of the representation can be done at the level of the DPC. The prohibition imposed by paragraph 47 in Equality Forum 1 would now no longer hold good, subject to the condition that the DPC, before embarking upon each and every promotion process, undertakes an exercise to determine the inadequacy or inadequacy of representation of the reserved category candidates in that particular given cadre where promotion is sought to be made. Next, your lordship will kindly see paragraph 45, where this clause 4 has been discussed and decided. A reading of clause 4 makes it discernible that if an occasion arises during the promotion process in which stipulated percentage in respect of reserved category is met, but in the gradation list, seniority list, there are candidates of reserved category candidates who on merit are also entitled to a promotion, her cases are to be considered for promotion on merit only if such candidate has not been given seniority by way of any accelerated promotion. It would mean that if a reserved category candidate is seeking for a promotion against any post in the promoted cadre, which is earmarked for a reserved category candidate, he would be entitled to the benefits of consequential seniority as provided in Office Memorandum dated 12 March 2002. But on the other hand, if the posts are earmarked for reserved category candidates are already exhausted by being occupied by the reserved category candidates, but in the gradation list there remains some further reserved category candidates, they can compete for promotion against the unreserved posts. But in such event, they would not be entitled to the benefits under consequential seniority. And on the other hand, if on the basis of their seniority otherwise, without taking note of the consequential seniority they are within the zone of consideration, such candidates can be considered for promotion. So therefore, the question that merely because I earned an accelerated promotion before, and therefore I could not come,
Para 45 is a recital of the,
para 45,
is just a recital of the clause 4.
but
Where is
yes,
the finding?
no, the finding is there, my lord, in particularly it will be
The
Six
issue
line.
was whether quantifiable data is required or not. That has been held not required, backwardness.
yes. Quantifiable data on backwardness, inefficiency in
But
administration, etc. are not required.
whether the 16 notification supersedes 2002, where is the finding?
Now, this clarification has been given, if your lordship will kindly read from 9th line from bottom, it starts with, it would mean,
In para 45.
para 45, it would mean, my lord, this is the interpretation given. It would mean that if a reserved category candidate is seeking for a promotion,
Hmm.
if it would mean that if a reserved category candidate is seeking for a promotion against any post in the promoted cadre, which is earmarked for a reserved category candidate, he would be entitled to the benefits of consequential seniority as provided in the office memorandum dated so and so.
Hmm.
But on the other hand, if the posts earmarked for the reserved category candidates are already exhausted,
Hmm.
already by being occupied by the reserved category candidates, but in the gradation list there remains some further reserved category candidates, they can compete for promotion against unreserved posts, but in such event, they would not be entitled to the benefits under consequential seniority. And on the other hand, if on the basis of their seniority otherwise, without taking note of consequential seniority, they are within the zone of consideration, such candidates can be considered for promotion.
That is a further explanation of 4. 4 says if you are down below, you're reserved,
Hmm.
vacancies are available, then you'll go.
Then I will go, but I will not go provided
You'll go.
if I earned accelerated promotion in the past and the vacancies are made.
No. There are two situations. Vacancies available, you will go.
Yes.
Irrespective of consequential seniority, etc. Vacancies not there, you will not go if otherwise you did not have the benefit of accelerated seniority.
No,
If you had the benefit of accelerated seniority.
that 4 says, that is what 4 says.
4 says.
But the
The
interpretation,
clarification is that if you are otherwise within the zone of consideration,
yes, regardless of my accelerated promotion and seniority and all, regardless of my accelerated promotion, I can still go for go.
What is
within
the
zone of
criteria?
consideration
what
and
is
I
the
can
criteria for promotion? Merit.
merit comes seniority.
Merit.
Merit comes seniority.
Merit comes seniority.
And here, my lord, the on seniority, I am senior to him, and merit was found to be equal.
But if I may interrupt for a moment,
Hmm.
that same paragraph 45, the last sentence, last
Hmm.
portion.
Yes.
In fact, if your lordship starts reading from, but in such event, it's a continuation of a sentence
Hmm.
towards the bottom of paragraph 45.
Yes, but in such event.
But in such event,
Hmm.
they would be entitled to the benefits
They
under,
would not be.
they would not be entitled to the benefits under consequential seniority. And on the other hand, if on the basis of their seniority otherwise, and further clarified, that is without taking note of consequential seniority, they are within the zone of consideration, such candidates can be considered for promotion. So in a sense, para 4 has been upheld.
Now,
Because what para 4 says is, if in the past you have taken the benefit of consequential seniority, even if you are in the zone of consideration, you will not be entitled.
now,
And that is exactly what the judgment also says.
now the next paragraph, the judgment says that 7 except what had been stated above in the preceding paragraph, all other findings of the honorable single judge will hold good, unless they come in conflict with any of the observations or findings of this recorded in this judgment. Now, the one point that is common in both the judgments is that The validity of 2002 office memorandum has been upheld. 2002 office memorandum has not been interfered with, and the interpretation
But
that
the
was
right of the state to curtail these benefits also has been upheld.
yes, but single judge has said
Hmm.
that if the state wants to curtail this benefit, that has to come through a specified policy, a categorical policy. And
Then
office
who has
memorandum,
issued that notification?
now office,
Who
now,
issued that notification?
no, the state issued, but the office memorandum 2016, the interpretation of the honorable single judge was that by way of this office memorandum 2016, you cannot curtail the benefit which has been holding the field since 2012, 2002. It requires a specific policy of the state to be declared in that manner. And so to say, the 2016 office memorandum does not become a specified policy of the state. In fact, that is also an argument made in the division, made before the division bench, that since it has to be, it is an enabling provision the state can do away with. The validity of 2000.
That's right.
office memorandum-
So how will the state do away with?
That is for the state to come out with a,
But-
come out with a mechanism. But
by with office memorandums?
no, till the time, because no, here it is. the
Unless
office
you want
memorandum-
to say that no, it can only be done by statutory amendment.
No, this has been recorded because in the context of section 5A of the 78 Act. In the context of section 5A of the.
Essentially, since 5A is there,
Yes,
benefit must accrue.
must accrue.
Therefore, 2002,
Yes,
but 2000, clause 4 of 2016 is in contravention essentially with section 5A.
yes.
But the state also has the power to do away
So
with.
therefore, the honorable court has said that if you want to do away with this, you have to come up with a specified policy.
Which has
now-
come out in
now-
2016.
Now, my lord, 2016, with all respect, my lord, 2016 has not been able to hold approval of the honorable court to inhibit the benefit of 2002.
Now,
Now, in the context of the present case, my lord, this is the.
what is the finding of the division bench in so far as 4 is concerned?
Para 45. Para 45 only, my lord. So far as clause 4 is
What
concerned.
is the interpretation or meaning required to be ascribed to these last few lines of para 45?
In my humble submission, my lord, this has to be reconciled with 2002 office memorandum.
No, you kindly read that part, but in such event.
I'll read from little above, my lord. If the
Yes.
posts earmarked for the reserved category candidates are already exhausted by being occupied by the reserved category candidates, but in the gradation lists, there remains some further reserved category candidates. They can compete for promotion against unreserved posts. Now, this was not specifically in the, because the clause 4 is quoted in para 44. If your lordship just have a look at para 44, my lord, the clause 4 doesn't provide this opening. Clause 4 doesn't provide this opening that irrespective of the fact that position of vacancy is met, I can still compete against unreserved posts. This.
No, if the vacancy for reserve post is complete, is filled up.
And there are people in the gradation list who are
Yes,
from
yes,
reserve.
yes.
They can
Let us
compete
read the
against
clause 4. Let us read the clause 4.
Yes.
Para
Even,
44.
yes, even
Clause
occasion-
4 says that if the percentage of reserve category is met
merit.
and there are people in the reserve category in the gradation list
Ah.
who on merit is entitled to promotion, means their merit is suitable to other unreserved category.
Yeah,
Their cases will be considered if that candidate has not gained seniority. So
By-
assuming this is correct, you have not gained seniority by accelerated promotion, where will you be considered? Because the quotas are filled up. You can only be considered in respect of unreserved quota.
yes.
So to say that
That means here, my lord, what I understood, my lord, my position on merit was sought to be inhibited by a factor of me gaining accelerated promotion in the past.
No, no. You said that clause 4 did not provide an avenue for filling up unreserved posts. It is into that extent, I think it does, provided you do not gain consequential seniority earlier.
Provided I did not gain a consequential
Ah.
seniority earlier.
Now, in that
So-
context, let us see what the division bench has said.
Now, if the posts earmarked for the reserved category candidates are already exhausted by
Yes.
being occupied by the reserved category candidates, but in the gradation lists, there remains some further reserved category candidates, they can compete for promotion against the unreserved posts.
Hmm.
But in such event, they would not be entitled to the benefits under the consequential seniority. That means holding me at par with the other candidates available within the zone of consideration, I am entitled to be considered for promotion. Only thing that I will not get consequent to my promotion is that I will not gain the consequential seniority. Supposing the situation is that in the feeder
If it
cadre,
is a merit cum seniority, the
yes,
selection criteria is merit cum seniority, and you are selected on merit
yes,
in the next higher post, you want to say that you will still not get your seniority.
no. The meaning that I could understand from this is this, Miller. Supposing in the feeder cadre, there are candidates who are competing against each other on merit cum seniority. And there are persons belonging to reserved category candidates competing against unreserved posts. He can compete, he can come within the zone of consideration. He can even get promotion, but he will not gain the benefit of accelerated seniority in the promotional post. Supposing I am senior in the feeder cadre than him. I am senior in the feeder cadre than him. And because I am competing against the unreserved quota post, I am gaining my entry there. Merely because I remain senior to him in the feeder post, I will not get the benefit of consequential seniority in the
That goes without saying because the criteria is merit cum seniority.
No, merit cum seniority is the basis for assessing our suitability.
Include you in the zone of consideration.
Yes.
Seniority is.
Yes.
And if the merits are equal, then the seniority comes.
Yes.
Now, in a hypothetical situation, you have sufficient merit to be considered along with the unreserved categories, but you belong to reserved category. Your reserved category quotas are filled up. By virtue of this, now you are considered along with other unreserved categories. Both your merits are similar, equal. Now, who will be the senior person in the next higher post? Both are selected.
No, my lord, there I'll try to make a little distinction. Since our merit are similar, I being senior, I'll steal a march over him. But in the promotion, when the question of fixing seniority in the promoted cadre will come, there I cannot claim the benefit of consequential seniority in the feeder cadre. That is the purport.
Then, see, that would be perhaps, I do not know, but your criteria for selection is merit cum seniority.
No.
Merit.
Suppose, my lord, there are 3 posts. The criteria for selection is merit cum seniority. Now, 3 persons are accordingly chosen and they are put in the position of the promoted cadre.
As per the select list.
As per the select list. Now,
The
after
select list will identify the positions
One,
in
two,
terms of
three.
merit.
Yes, 1, 2, 3.
1, 2, 3.
Now, among these 3 in the select list.
Assuming you are at number 3,
Yes.
by virtue of your earlier seniority, you will not become number 1.
Yes.
We understand that.
Yes. That is the purport of these lines, my lord.
That goes without saying because it is merit cum seniority. The seniority will have to be as per the select list.
No, my lord, perhaps
Ordinarily.
the thing can be looked into from this angle also. Merit cum seniority will be the basis for assessing our suitability for the promoted cadre or promoted post.
Correct.
Now, on the basis of this yardstick, we are promoted. 3 are promoted. And the question therefore comes that among the 3 inter se, who will rank senior to whom? The previous thing that was going on is that if I was senior in the feeder cadre, I will also become senior in the promoted cadre.
Promoted cadre.
That has been done away with. In these lines, my lord, The division bench has done away with that to that extent only. It has not interfered with the aspect of assessing the suitability vis-a-vis the candidates on the basis of merit cum seniority. It is on the basis of merit cum seniority rule only we will go. But after going there, we cannot claim that I was senior to, supposing, my lord, in a situation where,
Therefore, this seniority will be as per the select list.
no,
How else? How else will you fix it in the?
no, previously, my lord, the system that was being pursued was that since I was senior in the
No, I
Peter category-
understand that. In terms of this order, what happens?
yes, in terms of this order, it will be in order of merit in this election.
Merit. That's
Yes.
what I'm saying. That's what I'm saying.
Then I cannot claim
So-
that since I was
So
senior there.
essentially, you are saying the division bench has now opened up
Yes,
the leeway
yes,
for you to be included in the zone of consideration.
yes,
Notwithstanding your reserve category posts are filled up.
yes. My in the DPC minutes, my lord, they said they took me in the zone of consideration.
Hmm.
But they said that since the posts are filled up and you earned accelerated promotion in the past, so you cannot come. So
All right.
this has been diluted now.
All right, we'll come back.
Yes.
To that extent, my lord, my learned friend is right. But the last portion, starting from that is, i.e.,
I hope
Without
in
taking-
the second half also he'll say that I'm right.
without taking note of the consequential seniority, they are within the zone of consideration. So he will come within the zone of consideration, provided he has not taken the benefit of consequential seniority
That-
in the past.
We'll request the submission of Mr. R. Sharma, learned counsel for petitioner, who submits on instruction that writ petition has become infractuous. Matter stands dismissed as infractuous, interim order, if any, stands vacated.
Well, before I go back to the facts of the case, only one paragraph I will read from the judgment of the Honorable Division Bench. That is paragraph 16 at page 18. Paragraph 16 at page 18. In paragraph 14 and 15, my lord, the Honorable Division Bench has summed up the eventual conclusions by the learned single judge. And paragraph 16, my lord, from the judgment and order dated 6/6/2022 of the learned single judge, it is discernible that in respect of the challenge to clause 4 of the office memorandum dated so and so, it has been provided that the policy of providing reservation in promotion with consequential seniority having been holding the field as per OM dated 2002, the state is not within its competence and jurisdiction to deprive such benefit to a meritorious reserved category candidate, and that too without expressly bringing such policy by superseding the benefits granted under the office memorandum dated 12/3/2002. With regard to the challenge of the Society Equality Forum as regards the entire office memorandum dated 3/8/2016, it has been provided in the order dated so and so of the learned single judge in paragraph 7, Roman 8, that given the dictum of the Honorable Supreme Court in Jarnal Singh versus Lakshminarayan Gupta reported in so and so, the judgment dated so and so rendered in Equality Forum Supra has become redundant. In other words, by the judgment dated 6/6/2022 in WPC so and so, learned single judge firstly held that clause 4 of the office memorandum dated 3/8/2016 has to be interpreted in a manner that the policy of reservation in promotion with consequential seniority benefit having been provided by office memorandum dated 12/3/2002, it is beyond the competence of the state to deny service benefit to a meritorious reserve category candidate without superseding the earlier office memorandum dated so and so. And with regard to the claim of the society so and so, that although in paragraph 47 of the judgment in Equality Forum, it has been provided that till the quantifiable data is collected, the policy of reservation shall remain dormant, but the requirement of keeping the policy dormant shall not hold good in view of the subsequent judgment of the Honorable Supreme Court rendered in Jarnal Singh 1. So effectively, my lord, what flows from this is that the office memorandum 12/3/2002 has to be given a precedence over whatever has been prescribed in clause 4 of the 2016 office memorandum. And in that perspective, my lord, the claim of the petitioner before your lordship has to be examined. Now, if I come back to the writ petition, my lord, your lordship will kindly come to page 56, 55. That is the minutes of the selection committee.
Yes.
56, it starts from 56, my lord, 56 is relevant. Discussion was initiated by the secretary, PhD cum member secretary selection board with due permission from the chair so and so. Existing final inter-se seniority of superintending engineer, roster, register, service rule, SER statement, and other relevant papers before the selection board member vacancy, member secretary also apprised that 8 posts of additional chief engineer are lying vacant and 2 resultant vacancy will likely to occur during 2021 in the department. Zone of consideration as per said Rule 5 of Assam SC/ST reservation in vacancies in service and posts Amendment Act 2012 shall be 11 into 4, that is 44 numbers. Presently, there are only 14 officers exist in the cadre of superintending engineer as per approved inter-se seniority list, and no DP is pending or contemplated against those officers. My lord, for a taking pause for a moment, my lord, I'll just take your lordship to page 51, which is the seniority list.
Page?
51.
Yes.
This is the list which was considered during the DPC proceeding. Here your lordship will find my name appears at serial 6, page 51, annexure 12,
51 of
writ petition.
writ petition.
Your lordship was reading 56. I'm just going few pages back, 51.
Wait. Yes.
51, your lordship will find my name appears at serial 6, Jayantakumar Medhi, category SC. Then down below, there are one candidate, Dipendu Talukdar, he has by now retired. And serial 8 is Billamangal Rai. That is the private respondent represented by my learned friend. And then comes one Bhavan Hazarika, who is at serial 9. Now, this is the list which was taken into account while determining the zone of consideration and the available pool of suitable candidates. Now, if your lordship will kindly come back to page 56, third para, the selection board discussed about the qualifying service of superintending engineer required for promotion to the post of additional chief engineer. PAG Rule 12(5)(b) of Assam Public Health Engineering Service Rule 96 speaks that an officer who has rendered minimum 4 years continuous service on 24 years of total regular service, including 1 year as superintending engineer PHE on 1st January of the year of promotion, that's 2021, in the post of superintending engineer PhD as amended by notification dated so and so. But presently, one of them have completed required length of service. For other 11 number of incumbents, the personnel department has relaxed the qualifying service of the incumbent by so and so dated 2/8/21. Then this list is extracted here. So the next paragraph, the selection board discussed about the vacancy position of additional chief engineer PhE during 2021 and found that 10 numbers of vacancies occurred during 2021. 8 numbers existing vacancy and 2 resultant vacancy will occur due to retirement of Sushanto Das and Subodh Chandra Nath. Roster point UR 4, 6, 7, 9, 10, 11, 12, 13. Roster point 5 is STP. Roster point 8 is for SC. Roster point 14 for STH. Of L-shaped model roster register to be filled up
You
during
belong to
21.
which category? You belong to which category?
I'm SC. I'm SC.
Yes.
SC. The selection board followed the OM number so and so dated 3/8/2016 issued by the WPT and BC department and decided to fill up the vacancies. It was also observed that there is no STP and STH category incumbents available under zone of consideration, and the selection board decided to keep vacant RP roster point 5 meant for ST plain and RP 14 meant for STH. Selection board also noticed that there are sufficient SC category candidates come under zone of consideration and all the reserved category candidates availed accelerated promotion earlier. But the records placed before the selection board reveals that the immediate senior of Sri Pranab Kumar Talukdar and Sri Narayan Chandra Malakar as per initial gradation list were retired. As such, both are entitled for promotion on merit. Sri Kamal Medhi, who availed accelerated promotion, was recommended against roster point 8 meant for SC. Now, this is important, next line. Since Sri Jayantakumar Medhi had gained seniority by way of accelerated promotion, the selection board therefore not recommended Sri Medhi following para 4 of OM dated 3/8/2016.
How
Now,
many UR posts are vacant, unreserved?
unreserved were there were
There were 8,
7, yes, 4, 6, 7, 9, 10, 11, 12, 13, 88 posts.
8.
8.
So there are 8 candidates? No.
Eight.
How
No.
many candidates?
Total were 14.
Ah.
14 candidates were available.
No, how many for unreserved?
Now down below there is a list, my lord. Here only 2 candidates from general category have been accommodated.
What happened to the other posts? Vacant.
Others are vacant.
So 6 posts are vacant.
Yes. So my case was that even if I do not go against the vacancy earmarked for SC, I can compete against the open post. And the minute says, next line, the secretary cum member secretary of the selection board stated that minimum criteria for acceptance of SCR being good, after examining found that all officers satisfied the criteria. After examining SCR, MPR and IPR report and other related records, selection board recommended following superintending engineer for promotion to the post of additional chief engineer PHE. Then these 8 persons are recommended. My case is that since my seniority is position, which is
There are 3 general, not 2.
yes, sorry, three general. Serial number 1, serial number 4, and serial number 6. Now,
Now what is this serial number 2 and 3 SC on merit?
yes, they have been qualified against the merit quota.
How? They did not accept seniority. I mean, the accelerated seniority earlier.
No, this also, of course, it is not very explicitly said here, but it appears so. Going by their preceding recital, it appears that perhaps they had not gained the accelerated seniority. Question is, my lord, if I can secure it on merit, then going by the seniority list, which is at page 51, I stand senior to respondent number 6.
What is his number, respondent 6?
His seniority is serial 8. At page 51, he is at serial 8.
Serial 8.
And I was at serial 6. And this is the seniority I have maintained all along above him throughout the career, right from the promotion from the post of assistant executive engineer. Right from the post of assistant engineer, I have maintained this seniority above him. And my seniority has never been questioned, never been challenged. And it till that date, my lord, I stood senior to him. So if it is to go on the parameter of merit cum seniority, then I could compete against I could be considered against the general quota.
No, I think there are 5 posts filled up. OBC, MOBC probably is in the unreserved category.
Yes,
So that
Unreserved.
makes it 5.
5.
So there are 3 vacant.
And barring those 3, my lord, barring those 3, they could still accommodate me because it is their observation in the minutes. I'll read it further to your lordship that merit of all the candidates were found at equal. So I being senior to them, as per the seniority list at page 51, they ought to have considered my case.
But for that rider.
But for that rider. But for that rider that I gained accelerated promotion earlier, so I'll not be. This is the basic case. And in the next writ petition, your lordship will find
Now what happens if there is a review DPC?
that is one of my prayers in the writ
No,
petition.
so what happens?
Now, if the review DPC is directed, my lord, so then they'll have to sit with the exercise afresh by keeping the clause 4 of office memorandum dated 2016 at bay for certain reasons.
No. Hypothetically, assuming court directs review DPC, then we go back to that date when the selection
Yes.
was made.
Yes, yes,
But
And-
there were already three existing
yes.
vacancies. So at least besides you, if there are 2 other persons, they will also have to be considered.
Yes, they will also have to be considered. And
Yes. Okay.
in the other writ petition, my lord, In the other writ petition, if your lordship just for a moment takes up the DPC minutes, my lord. This is the same way, my lord, at page 53.
This part.
So based on this selection, my lord, the further promotion in the post of chief engineer was considered.
Now in the other writ petition,
In the other writ petition, my lord, the prayer is, your lordship will kindly come to page 28. The prayer is recommendation of Departmental Promotion Committee meeting held on 28/3/2022 for promotion of the respondent number 5 to the post of chief engineer be not set aside and quashed. A review selection committee meeting of the Departmental Promotion Committee for selection of candidate for promotion to the post of chief engineer of Public Health Engineering Department should not be held, and why the respondent be not directed to consider therein the case of the petitioner for promotion to the post of chief engineer. So this is the second writ petition is basically a
how many posts of chief engineer are there?
chief engineer. There are two. Huh?
Two.
Huh?
Two posts. So Mr.
But only
Chaudhary's
one-
client was occupying one
One.
and the other?
No, other one,
Other one was vacant to my instruction.
the other one perhaps has in the meantime retired.
So from the list at page 57,
Yes,
only one person became a chief engineer.
yes, only one.
Now I have also vacated since I have been promoted as a secretary. That also, that post perhaps, I don't know what is the position. The department will be able to know.
So basically, dehors the interference with the, that is other way of looking at the issue, my lord. Without even interfering with the minutes where his case was recommended in preference to mine. If the department had thought it prudent to fill up the posts which are otherwise available, they could have done so, but for the rider, they did not consider my case.
And the division bench judgment was not available at that time.
Yes, it was not available at that point of time.
All right.
Think, huh?
That's it.
Yes, that is my case. Additional.
Who's for the department?
Department,
What is
Mr.
the
PN Goswami.
what is the position in view of the division bench judgment?
I'll have to seek further instruction, and we had filed an affidavit on February.
You are a lawyer, you will have to read division bench judgment. What instructions will the department give you? Yes, Mr. Chaudhary.
My lord, my friend has placed some of the facts, but the facts in entirety will be necessary in this case. May I quickly indicate the dates, relevant dates?
You are addressing on which matter?
My lord, in the second case, 4570, all the facts are there in my affidavit. If your lordship takes up 4570 and the affidavit filed by us, respondent number 5, it's a reasonably bulky affidavit. That has all the facts. It is an affidavit filed on 1st of September 22 by the respondent number 5.
Yes.
First, your lordship will kindly turn to page 46 of that affidavit.
Huh?
Page 46.
Yes.
This is our original entry into service in the department. This is the select list. And your lordship will find the name of the respondent number 5 at serial number 4.
Yes.
And then, if your lordship kindly turns the page at page 47, at serial number 10 is the writ petition. Jayanta Kumar Mitra. So this was the original position when we entered into service. So naturally, by virtue of this select list, I was senior at the time of entry. Now what happened? In the year 2007, in the meantime, that 85th amendment comes. Now, in 2002, that OM is issued providing for consequential seniority. While we are serving at the entry level post, assistant engineer. So once that OM comes, he is given accelerated promotion, which your lordship will find at page 70. I'm sorry, my lord. 69.
Yes.
Award. Page 69, your lordship will kindly note the date, my lord. 12th of December 2003. So this is a consequence of that OM of 2002, which provided for accelerated promotion and consequential seniority. Now he steals a march over me in 2003. I am promoted by the next page, subsequently in 2007. He is not promoted on merit. He is promoted by virtue of his reserve category status.
Yes.
Now, in 2007, I am promoted. In the meantime, there is a development, my lord. The development is Nagraj has in the meantime come. So, your lordship may just make a note of the date on which Nagraj was delivered. That has a significance in this case. Nagraj was delivered on 19/10/2006. Now, 2007, when I get promoted, I ought to have been, my seniority position ought to have been restored by virtue of Nagraj. That does not happen. Why I'm pointing out these facts is that clause 4, what is the relevance of that? It will emerge from these facts. Now, they publish, although these promotions take place in 2003 and 2007, the seniority list of assistant executive engineer is
No, just to ask a query. See, whichever way the interpretation you may like to go, but the interpretation given by the division bench will have a binding effect.
yes, sir. And in fact, that is what I was coming to.
So,
It supports precisely.
so in the interpretation of the division bench, how would you like to interpret in a manner which is different from the interpretations ought to be given by the petitioner?
But there cannot be any difference at all.
Ah,
If your lordship will kindly come back to para 47 of the division bench,
yes,
keeping aside the facts for a moment.
yes.
What it intends to do, 45 one.
40,
First, your lordship will kindly come to 44,
44.
which has para 44 has extracted that clause.
Hmm.
What it says is this: if an occasion arises during the promotion process in which stipulated percentage in respect of reserve category is met, but in the gradation list, seniority list, there are candidates of reserve category who on merit is entitled to the promotion, her case shall be considered for promotion on merit if such candidate has not gained the seniority by way of any accelerated promotion earlier. So the rider is that you will get the benefit of being considered at par with the other candidates on merit. But if you have availed of accelerated promotion and consequential seniority at an earlier point of time, you will not get that benefit.
So in a sense, this was to restore the catch-up rule.
Catch-up rule, exactly. And in this context, now your lordship will kindly read the last few lines. I am laying emphasis on exactly the same portion where which I had read out earlier. Para 45 towards the bottom of page 34, your lordship will find the sentence starting. Or earlier it says that you will get the benefit of being considered on merit But in such event,
Hmm.
they would not be entitled to the benefits under the consequential seniority. And on the other hand, if on the basis of their seniority otherwise, the senior, if I may pause here for a moment, madam, seniority otherwise can only be by the seniority on merit. That is, the division bench makes it further clear, madam. That is, without taking note of the consequential seniority, they are within the zone of consideration. Such candidates shall be considered for promotion. So, if you have taken the benefit of consequential seniority and you have jumped the queue on an earlier occasion, you will not be entitled to a consideration on merit.
No, but we are trying to understand the interpretation.
That is what I'm.
The
After
interpretation.
that, I,
Hmm.
that is, without taking note of the consequential seniority, they are within the zone of consideration. Such candidates can be considered for promotion. So, you will be entitled to a consideration on merit if that original position had been maintained and you had not jumped the queue, taken the benefit of consequential seniority. Otherwise, your lordship will again go back to that original select list. I was at serial number 4, he was at serial number 10. There was no way he could have superseded me at any point, earlier point of time, only for the benefit he availed. So that is what has been sought to be negated by this division bench judge. Although that is why, my lord, we'll have to understand this case in the context of the judgments, constitution bench judgments delivered by the apex court.
So you kindly read out from this part.
Yes, sir. In fact, let me start from the very beginning. A reading of clause 4 makes it discernible that if an occasion arises during the promotion process in which stipulated percentage in respect of reserve category is met, but in the gradation list, seniority list, there are candidates or reserve category candidates who on merit are also entitled to a promotion. His or her cases are to be considered for promotion on merit only if such candidate has not been given seniority by way of accelerated promotion. It would mean that if a reserve category candidate is seeking for promotion against any post in the promoted cadre, which is earmarked for a reserve category candidate, he would be entitled to the benefits of consequential seniority as provided in the OM dated so and so. May I pause here for a moment? This envisages a position that if there are reserve category posts available, he will definitely get the benefit of 2002. But on the other hand, if the posts earmarked for reserve category candidates are already exhausted by being occupied by the reserve category candidates, but in the gradation list there remains some further reserve category candidates, they can compete for promotion against the unreserved post. But in such event, they would not be entitled to the benefits under the consequential seniority. And on the other hand, if on the basis of their seniority otherwise, that is, without taking note of consequential seniority, they are within the zone of consideration, such candidates can be considered for promotion. You will definitely get the benefit, provided you have not jumped the queue by taking the benefit of accelerated promotion and consequences.
Now, how is it to be determined? Their original seniority?
Go back to the original select list. Because ultimately your lordship is aware.
No, in the original select list, let us talk about where is that original select list here?
Here it is at page 46 of the affidavit.
46.
Till the level of superintending engineer, your lordship is aware, the criteria is seniority. So there is no way that he could have jumped the queue, but for the benefit.
46 of the writ petition.
46 of the affidavit, my affidavit.
Oh, your affidavit.
Running page. More affidavit.
Yes, 46.
So-
Combined list.
This is the select list.
Hmm.
And
This is the select list for
select list published by the APSC one.
for which post?
Assistant engineer. The entry level post is assistant engineer.
Now, from here, next promotion will be assistant executive.
Assistant executive. In fact, my lord, to make the position further clear, based on this selection, there was a seniority list also published.
Hmm.
That is, your lordship will find at page 63.
63.
This is the inter-se seniority list of assistant engineers. And your lordship will find the name, both the names at page 64. Page 64. My name is at serial number 32 and his name is at serial number 38. So
This is in which post?
assistant engineer, that entry level post,
Assistant engineer, okay.
because this will be, this had to be prepared.
Now in the next post, what is the seniority list?
Now in the next post, since he jumped the queue, he got a promotion in 2003. I got it in 2007. The seniority list that was published is at page 37. I'm sorry, my lord, this is at page 37 of page 71.
Yes.
So in 71, your lordship will find that since he was promoted earlier, he is shown at serial number 16 and I am shown at serial number 24. So he gets the benefit of accelerated promotion as well as consequential seniority. Am I clear, madam? So this is what the division bench has now clarified, that if you have taken this benefit at an earlier point of time, you will not get the benefit of competing with the others who have come on merit. And this position continued. Not only, my lord, Nagraj came. Thereafter, your lordship is aware, my lord, in 2010, Suraj Bhan Meena was rendered by the Supreme Court. Then UP Power Corporation in 2012. So the position all through remained that in absence of quantifiable data, it is the catch-up principle which will apply. So in 2016, the authorities realized that this is not the case only in this department. In several departments, this problem had arisen. So to negate the people who had jumped the queue at various stages in their promotion, in their careers, to be fair to the general category.
If we accept your arguments, you see, essentially the division bench did not interfere with the orders of the single bench.
No, division bench clarified so far as clause 4 is concerned.
Correct. Others did not. The ratio of the single bench is 2002 prevails. Is it 2002?
Yes.
2002 prevails. So
But
if the benefit is to be taken away, then state is empowered, but you have to come with proper notification, policy decision, etc., etc.
and that policy decision is clause 4.
Now, division bench judgment essentially did not interfere with that. If we accept this clarification as you are arguing, then it will amount to that this order of the single bench has been substantially interfered with.
To that extent, my lord, there is
not only to the extent of interpretation of 4 in 16, but also with regard to 2, which means that 2 by this interpretation, 2 has been given a go by.
there is a that is where let me clarify the position. Neither the single bench nor the division bench has said that 2002 will have an all-pervasive effect. At the same time, clause 4 as such has not been struck down.
What did 2002 essentially say?
Consequential seniority.
Consequential seniority.
But that will again be, your lordship is aware, my lord. As soon as the 85th amendment came, this 2002, without any application of mind to this requirement of quantifiable data was issued. Nagraj came later. Nagraj came in 2006. Nagraj made it very clear that you will have to collect quantifiable data in respect of 3 different aspects. Number 1, backwardness. Number 2, inadequacy of representation. And number 3, efficiency in service.
Followed by Mina, etc.
Yes.
All the
So, but Nagraj was in the context of a challenge thrown to the 77th and the 85th amendment. Nagraj was merely testing whether these amendments are valid or not. And Nagraj said that they are valid subject to the condition that
You have the data.
you have the quantifiable data, because it is merely an enabling provision to exercise the power conferred in 16.4 or 16.4a. You have to undertake the exercise of finding out. Nagraj made one error, which has been subsequently rectified in Journal Singh. It said backwardness, adequacy of representation, and efficiency in administration. 3 different aspects. You will have to collect quantifiable data. Ultimately, when the matter was once again referred back to the Constitution bench to test Nagraj in Journal Singh, the only issue before the Constitution bench was whether out of these 3, backwardness also could have been included, because backwardness is inherent. The moment you are making a reservation, the element of backwardness is already inherent. So therefore, ultimately, Journal Singh said that Nagraj, to the extent of saying that you will have to collect quantifiable data also with regard to backwardness, that is the only interference. So far as adequacy of representation and efficiency in service, these 2 aspects, quantifiable data, still remains a mandatory aspect. Now, all these facts, 2002, obviously there could not have been any quantifiable data. Now, Nagraj, followed by Meena, followed by UP Power Corporation. In fact, there is a judgment, I'll place that, my lord, BK Pavitra, where the apex court has said that if there is no quantifiable data available in respect of a particular cadre, catch-up principle is automatic. So, if we try to say that 2002 only because it has not been touched either by the single bench or by the division bench, it will have an all-pervasive effect. It will be an incorrect interpretation, because that will go against the mandate of the Constitution bench in Nagraj and Journal Singh. It will go against the Supreme Court in Meena, UP Power Corporation, etc., etc. In fact, my lord, may I place that BK, before I proceed any further, may I place that?
We'll look into it, but we want to know the effect of the division bench judgment, because if it is the interpretation which the court thinks it is, then it is binding.
Yes, it is. In fact, my lord, any other interpretation to these last, particularly this last portion of the sentence, that is without taking note of the consequential seniority, they are within the zone of consideration, such candidates can be considered for promotion. If it is interpreted to mean that even if they have taken the benefit of consequential seniority, they will still be entitled.
Does it require an interpretation?
It cannot, because in view of this laid down law by the apex court. If your lordship will kindly read that portion once again. Seniority otherwise, that is, without taking note of the consequential seniority, they are within the zone of consideration. Such candidates can be considered for promotion. I don't think there's any ambiguity in this sentence. That if you have not taken.
Let us apply it to the facts of the case.
Well,
how many posts were there? 2.
No, total 8 posts. So far as additional
8 posts. So what is the zone of consideration?
It should have been 8 into 4, but so many candidates were not available. So
therefore,
whoever was available was in the zone of consideration.
So therefore, even if you take away the zone of consideration, the consequential seniority, see, essentially the interpretation which you're trying to give now would be that the TPC will have to go back to that original select list and find out who are the candidates.
No, not necessary. Because their service records are before the DPC. They will automatically know.
No. Then how do you apply the finding of the division bench in the end? That if they have not, without taking note of their consequential seniority. So the benefit is not closed, but if on your own, if what your interpretation is, if you do not take note of the consequential seniority, you take aside this consequential seniority for the moment. Now you take the seniority as it was then, and now see the merits. If that person comes into the zone of consideration, then you'd be eligible. Is that the interpretation? So for that interpretation, you'll have to find out how many vacancies, eight. How many were there? Eight. So 8 vacancies into 4, 32. So within these 32 persons, whether this gentleman was, had he not taken a consequential benefit,
Would he have come or not?
would he have come? Don't you think it is too far-fetched for the DPC to go back
No,
10, 15, 20 years?
they
and find-
don't have to go back, my lord.
How?
Any seniority list, if your lordship looks at any seniority list, the dates are reflected. Now, as I was pointing out, my lord, till the level of superintending,
No. According to you, the basis is that entry-level seniority list. That gives the original position.
he could have, the only way to steal a march is consequential seniority.
Yeah,
Otherwise,
correct,
no.
correct. But over a period of time, between assistant engineer to the post of additional chief engineer, there are how many promotions? 3?
Mm.
Assistant
Assistant to assistant executive to executive to SE,
superintendent.
Superintendent. Yeah.
superintending,
3 promotions.
3 promotions.
So in these 3 promotions, on his own merit, he could have stolen a march without consequential seniority
He could not have, because the criteria is seniority
up to.
up to superintending.
Okay.
So he could not have stolen a mark. That is the reason. That is why I was trying to point out to your lordship, the first aspect here is, on
the-
3 occasions,
So
my
the
lord,
merit comes into play only with from the post of additional
SC and above,
SC or additional chief.
additional chief,
Superintending.
engineer and above. So what had happened was, had he not got these earlier promotions and consequential seniorities assigned at the level of assistant executive engineer or executive engineer or SE, he would not have perhaps even come into the zone of
So
consideration.
that will mean that your interpretation will mean that exactly what clause 4 says.
That is what they have done also. If your lordship again comes back to,
We are on the ratio laid down by the
yes.
PB.
So that is why I pointed out both the aspects, my lord. Para 44 extracts the clause 4, and that is what has been interpreted by the division bench.
If your interpretation is to be accepted, then this is what essentially clause 4 says.
Yes. In fact, there is a clarification to the extent
Therefore,
which my
if
learned
you
friend
have-
is right.
If you have taken,
Hmm.
if you have taken the benefit of consequential seniority, you cannot be considered for promotion against the unreserved category. That is what clause 4 says.
Yes.
But clause 4 does not put a full stop to that. Clause 4 says, if you are otherwise in the zone of consequential,
Hmm.
if you did not take up that consequential seniority. Now, that did not require any clarification insofar as the division bench is
No,
concerned.
there was what if your lordship again reads from that sentence
Because
starting,
if
it would mean.
this is the interpretation, this is the interpretation of clause 4, and this is the interpretation of the division bench, then this has been negated by the single bench.
Yeah.
Single bench said clause 4 cannot be there in view of 2002.
2000. To that extent, there is interpretation by the division.
So if division bench says exactly what the clause 4 says,
So in essence, clause 4 has been upheld.
no. Either we'll have to say that the division bench did not answer the question of whether clause 4 2016 prevails
But we-
over
At the
2000.
same time, we cannot ignore my lord, para 45. Para 45, the division bench has undertaken the exercise of clarifying clause 4.
No, that is what precisely the court wants to know. What is the clarification?
To that extent, there is a confusion, my lord. To that extent, my lord, informally, we were having a chat during the recess.
This
This will require
I-
some amount of
I find
examination.
it difficult to accept that this realization came only during the informal chat.
But
Therefore-
my lord,
Therefore, one of you ought to have gone for clarification.
so far as, my lord,
Like,
so far we have been
idea
on
of
the,
Sitting for a clarification is a bit,
Yeah.
his idea of sitting for a clarification is a bit long drawn.
No. Obviously, single bench can't clarify on this. Either it is binding or I differ.
my interpretation is, my lord, my understanding is that clause 4, to that extent, it has been upheld. The only clarification is that clause 4 does not say that you consider those who are otherwise there on merit. That aspect has been added by the division bench in para 45. What it says is this, my lord. Again, if I read it, start reading that
So,
sentence
The
starting, it
division
would
bench has said exactly what the clause 4 has said.
Yeah.
In a different,
in a different language.
not language, in a different tone, but the meaning,
Is
if you
exact.
compare, it's the same meaning, one and the same meaning. But it does not say that therefore, to that extent, the finding of the learned single judge is
Wrong.
interfered with.
That is what has perhaps created the confusion. After writing para 45, there ought to have been an indication that to that extent it stands. In fact, my lords, if we read para 46 for a moment, your lordship will kindly have para 46.
Yes.
Upon the issues being raised in the present appeals, having been decided in the manner indicated above, it is further provided that the decisions rendered in the present judgment in WA number so and so, so and so, so and so, would prevail over all such provisions of the learned single judge in the judgment dated 6/6/2022 in WPC number so and so. But in respect of any other provisions which may not be contrary or inconsistent with the provisions of this judgment, the same may prevail. But with a further clarification that if any such provisions of the judgment of the learned single judge is in conflict or contradictory to any of the provisions in the present judgment, such provisions and the judgment of the learned single judge stands modified accordingly. So therefore, my lord, but in any case, my lord, going back to that technical objection that I had raised, unless a challenge is made to my promotion as chief engineer, the order of promotion, the DPC is only merely a recommendation. That recommendation has been given effect to by whoever an order. Thereafter, my lord, I have faced the selection for the purpose of being appointed as secretary, and that selection has also attained finality by issuance of an order appointing me as, promoting me as secretary. Those are not even under challenge. Whether your lordship would undertake such an
His appointment to chief engineer is under challenge.
no,
Sorry, additional chief.
additional chief is under
Additional chief is.
additional chief is under challenge, but
The additional chief and all consequential.
These are all-
but it will have a cascading effect. If your lordship,
Yes, it will have a cascading effect, but
your lordship sees that if there is an interference caused to the, assuming your lordship causes an interference with the selection and appointment as additional chief, it is not just me alone. There were several other officers. The moment a review DPC is directed to be done, there are so many officers who have in the meantime retired. All of their cases will have to be opened up.
so therefore, that will have to be taken care of by the department. Otherwise,
It will,
assuming we hold that there is no modification or change to the views of the learned single judge in respect of clause 4. We are concerned with only with clause 4.
Yeah.
Nothing else.
no, there's.
Clause 4 and the effect of 2002 in the context of the determinations made.
No, but I would respectfully submit, my lord.
2002 only with regard to clause 4.
Yes.
That's all. Other.
There are areas.
Hmm.
That is what I was, that is, clause 4 is only one of the areas.
Hmm.
There are, my lord, several other aspects where I'll have to place the Supreme Court judgments. To point out to your lordship that what has been done is like, for example, the promotions, all the promotions and consequential seniorities given subsequent to Nagraj and UP Power Corporation were all.
Yes. Carry on. Yes.
Were all in violation of UP Power Corporation, Meena, BK Pavitra, etc. In fact, my lord, may I place that? That will what I am trying to draw your lordship's attention to. If your lordship allows me to place that a compilation to you, extra copy of it. We have already given a book list. If your lordship will take up BK Pavitra for a moment. Citation is 2017 4 SCC 620. Just one sentence I wanted to point out to your lordship. Any other interpretation or action will be directly in conflict with this particular 2017 4 SCC 620.
Is it reflected in the learned single judge's order?
That is not even considered. Neither single judge nor division.
In the division bench, there is a reference to detail.
It is referred to, this judgment is referred to, but this aspect, what I am about to
You
point
can
out.
read, you read. You read.
Just one sentence. After having examined the entire the development of the law pursuant to the 77th and the 85th Amendment, discussing Nagaraj, etc., Meena and everything. Finally, what the Supreme Court says is this. This sentence is very important. In absence of exercise under Article 16(4)(a), it is the catch-up rule which fully applies. And this is still a good law. BK Pavitra has never been touched by the Constitution bench at any point of time. If this is the mandate of law, each of the promotions and consequential seniorities that he has earned earlier are all illegal. If that be so,
But they're not under challenge.
they are not under challenge. I am on a different point. What I am trying to point out is,
He doesn't get any right.
and your lordship will not strike down something if it has the effect of reviving an illegal or earlier illegal. Gade Venkateshwara.
We are not, there is no question of striking down. We are only on the question
Of review the case.
of if clause 4 is upheld by the division bench, then it is binding. Therefore, it now calls for a review DPC.
No. In that case, there is not, he has not been deprived at all. If your lordship holds that.
No. If the ratio of the learned single judge says that clause 4 cannot be read without having reference to the 2002 and 2002 will prevail. So if that is the view we accept as is the interpretation given by the DP, then it has to be as per 2002.
No. To that extent, there is a clarification in para 45.
Here's the clarification. The matter has to go back for a review DPC.
But
Unless you are more forceful with the clarification at para 45.
para 45, that last sentence I am laying emphasis on. The division bench has very clearly said that if you have taken the benefit once, you will not be considered on merit.
Now, because for consideration to the post of additional chief, assuming what you say is the interpretation of the division bench, is the finding of the ratio of the division bench judgment, then there may, hypothetically, there may be a case, a person who did not get the benefit of accelerated promotion. You'll have to look into the seniority list for interpreting division bench ratio as in the manner that you want us to. You need not go back to the original seniority list. You'll have to go to the feeder category, which is superintending engineer.
Yes.
So you take out the superintending engineer list, and from there you'll have to now find out person who have not got the benefit of consequential accelerated promotion.
If you're
Now, there may be a particular case where a person, that benefit have been deprived to somebody else because he was not given that benefit in the feeder category, original feeder category.
in fact, my lord, if your lordship comes to the DPC minus for a moment, in my affidavit, your lordship will find it at page 110.
110.
110 of my affidavit.
Your affidavit. Yes.
That is what the authorities have done, man. If your lordship it starts at 110. If your lordship comes to 111, that is the recommendation. Your lordship will have a look at serial number 2 and 3. They are both SC candidates and they have received a.
This is one other issue. This is one other issue that the state will have to address.
Yes.
How these SC categories have been picked up? Is it a case that they did not avail of?
They perhaps did not. That is why they got it.
I mean, as the question opens up now, if your lordship will kindly come to page 44 of my writ petition, it will clinch the point that in the feeder cadre of superintending engineer, my promotion was on merit, not because of some accelerated seniority. Your lordship will kindly come to page 45. So if the pool has to be created in a manner where the people whoever are there are on the basis of their merit and not on the
You got accelerated promotion at which post?
assistant executive engineer and executive engineer.
Two.
Then why do you say it is on merit?
Page 45.
No, earlier ones were.
Page
Obvious.
45, 44 is my promotion recommendation for promotion to the post of superintending engineer. And page 45, your lordship will kindly see. Serial 6, Jayanta Kumar Medhi against roster point 4 unreserved on merit. So the additional chief engineer, the feeder career is superintending engineer, where I have not come on accelerated promotion. So your lordship's query, that assuming an hypothetical situation, that is exactly the situation prevailing in the case.
These were not pointed out before the division bench during the hearing.
No, this case was not before the honorable division.
No. These facts in respect of your selection, promotion.
No,
the earlier
these writ petitions were not.
These were not there. Okay.
Not there.
Yes.
So, my lord, coming back to the facts, your lordship will just make a note of these dates, which all are the promotions he got on the basis of accelerated promotion and consequential seniority. Your lordship will first note the date of his first promotion that he got as assistant executive engineer. That is at page 69 of my affidavit. His date of promotion is 12/12/2003. And there is no dispute that here the criteria of promotion from assistant engineer to assistant executive engineer is seniority cum merit. So the only way he could have stolen a march over me was by virtue of the accelerated promotion that he received. Page 69.
Of your affidavit.
My affidavit. That has all the facts. If your lordship takes that up, your lordship
Yes, page
won't have
69.
to. Page 69.
Yes.
So
This is for promotion to
assistant executive engineer. This is the writ petitioner, and next page is me. 3rd October 2007. Now, they published the seniority list.
So this 2003 was on accelerated promotion.
Yes. Now, if your lordship kindly comes to page 71. Your lordship will kindly note, this is the seniority list. Your lordship will just make a note of the date. 15th of December 2016. In the meantime, Nagraj, Meena, Power Corporation, everything has come, which says that if quantifiable data was not available, catch-up principle will apply. Therefore, they could not have placed Jayanta Kumar Medhi at serial number 16 and put me below him at serial number 24. So this position ought to have been rectified by them.
There was no challenge to it.
There's no challenge. There was no requirement because the mandate of law has to automatically come into play. Now, thereafter, your lordship will kindly come next to his promotion as executive engineer. Naturally, again, your lordship will just make a note of the dates. He was promoted on 9/2/2018 as executive engineer. And I was promoted later on. Because the position was not corrected, I was promoted on 21st of August 2018. And this position, again, accelerated promotion and consequential seniority, this position continued. And ultimately, when he became SE, naturally he continued to rank senior than me. Now, at the time of consideration of the additional chief, this is what the OM was very much enforced. Even if now it is held that it has been interfered to some extent, on the date when the DPC sat, the OM was very much enforced. And they applied the principle laid down in the OM, saying that since you have availed of consequential senior, accelerated promotion and consequential seniority at a particular point of time, we will not consider your case on merit. Your lordship will just take a note of the date, my lord, the date of the DPC for this thing, for SC to additional chief, which has been challenged in one of the writ petitions, is 24/8/2021. And the judgment of the learned single judge came on 6/6/22, almost a year later. So when the DPC sat, it was very much enforced. It was not touched by the either the honorable single judge or whatever modifications or otherwise. These judgments have not come into play. So there cannot be any illegality inferred. As your lordship is aware, my lord, a judgment cannot furnish a cause of action. On the date on which DPC sat, that OM was very much enforced.
Yes.
As will be reflected from that page 110, if your lordship will kindly come to the DPC minors. At page 110, at the very top, your lordship will find the date. Minutes of the selection board meeting held on 24/8/2021.
Yes.
And the single bench judgment came on 6/6/22, long thereafter.
And promotions
Promotions affected, my lord. I was promoted
prior to that.
much prior, my lord. DPC, my lord, sat on 24/8/21. I was promoted, my lord, on 10/9/21. This is annexed in the writ petition itself.
112.
112. So all of this were much prior to the single bench judgment. So whether one of the questions that your lordship will have to perhaps answer is whether a judgment can furnish a cause of action for this, for interference of an action taken under a valid OM, which has not as such been interfered with. And the other relevant dates are, my lord, the DPC for additional chief to chief is 28/3/22. That is also prior to the single bench judgment. And I was promoted on 31/3/22, which is also again prior to the single bench judgment. Even up to the cadre of chief engineer, I was promoted way before the single bench judgment came.
Okay.
So therefore, my lord, besides relying on the division bench as it stands now, my first limb of my argument is that the division bench has taken care of clause 4, and in fact has rather, as has rightly fallen from your lordship, has clarified it and in a way upheld clause 4. And the second limb of my argument is, my lord, the moment if your lordship causes an interference, it will amount to reviving something which is not permissible by virtue of all these catena of judgments following Nagraj. It will amount to giving the reviving a situation where he was given accelerated promotion and consequential seniority without any quantifiable data in existence. So that perhaps your lordship will not do.
But that was never under challenge. To that extent.
It may not be, madam. That is the principle. If your lordship has a look at Gade Venkateswara Rao for a moment, madam. AI 1966.
You give us a list of the judgments.
List is already given in the morning.
We'll take it up.
AI 1966 Supreme Court 828.
Yes.
Here also it was not under challenge. The earlier illegality was not under challenge. But what the apex court said, and in fact, what the apex court has said is, since it's a exercise of an extraordinary jurisdiction, it will the writ courts will not cause an interference if it has the effect of reviving an earlier illegality. And in fact, following this is the first in point of time. That is why I am placing this one. After that, there are other recent judgments also. AR 66 Supreme Court 828. The relevant paragraph is para 17.
Okay. Yes.
I'll very slowly read the relevant portion. One.
So that's not necessary. We will.
And
The only issue is what is the interpretation of the division bench. That is the core issue.
that is the core issue. There is no doubt about it. And on that, my lord, my respectful submission is that
It has sustained the clause 4.
it has sustained the clause 4 because anything otherwise would be contrary to the Supreme Court judgments. It will amount to giving the benefit which has been taken away judicially by the Supreme Court in a catena of judgments. If there is an interpretation otherwise, it will be contrary to the Supreme Court judgments.
Can you read para 46 again?
My lord. Upon the issues raised in the present appeals having been decided in the manner indicated above, it is further provided that the decisions rendered in the present judgment in WA number so and so and so and so and so and so would prevail over all such provisions of the learned single judge in the judgment dated 6/6/22 in WPC number so and so and so and so. But in respect of any other provisions which may not be contrary or inconsistent with the provisions of this judgment, the same may prevail. But with a further clarification that if any such provisions of the judgment of the learned single judge is in conflict or contradictory to any of the provisions in the present judgment, such provisions and judgment of the learned single judge stands modified accordingly. So to that extent, my lord, para 45 will have to be understood to be a modification of the learned single judge's judgment to that extent, to the extent of para 45. And para 45, as has fallen from your lordship, is more or less upholding of clause 4.
Not more or less, it is.
It is upholding.
Yes, Mr. Doctor.
The only thing in rejoinder, I would say, as I said, the promotion in the feeder cadre, superintending engineer.
We are not asking you for a rejoinder as yet, because the state is yet to open up. What we want to know is reading para 45 and 46. It appears that some portions were
No,
modified accordingly by the division bench.
my lord, but if it is read as a whole, the judgment read as a whole, 2002 has not been interfered with.
No, that is if you interpret, that is the whole issue. The para 45 holds the clue to the interpretation. if para 45 is to be interpreted, because para 45, para 46, nowhere it has said that clause 4 has been interfered with or set aside or anything like that.
At the same time, it has also not been said that it is accepted.
No,
Okay.
but para 46 says that in view of the findings of this court, of the appellate court, all these provisions of the single bench are held to be modified. So in that context, if para 4 is to be interpreted in the manner given in para 45, then it will have to be accepted that the views of the learned single judge vis-a-vis 2002 has been amended, modified, or interfered with.
But the honorable division bench has recorded this, that this 2016 memorandum, it is only in exercise of a review of the existing policy. It has been quoted in the judgment. If your lordship will kindly see page 15.
Page
15 of the judgment.
15.
Review
Yes.
of the government policy of reservation in promotion with reference to Honorable Guwahati judgment. Basically, it's a fallout of that Equality Forum judgment. With a view to bringing the policy of reservation in promotion for reserved categories in line with the directions of the Honorable High Court, government have reviewed the existing procedure of effecting reservation in promotion and accordingly lays down the following guidelines to be followed while considering promotion in any cadre in any establishment. Number 1, the policy of reservation in promotion shall continue. Then comes this, clause 3. If no eligible incumbent belonging to the shortfall category is available within the zone of consideration, this will further substantiate the status of backwardness and inadequacy of representation. Well, we are not concerned with inadequacy for a moment. The clause 4 is, if an occasion arises during the promotion process in which stipulated percentage in respect of reserved category is met, but in the gradation list, seniority list, there are candidates of reserved category who on merit is entitled to promotion. His or her case shall be considered for promotion on merit if such candidate has not gained the seniority by way of any accelerated promotion earlier. Now, this has been interpreted in para 45, and para 45, these lines, I am reading again, my lord. It would mean that if a reserved category candidate is seeking for a promotion against any post in the promoted cadre, which is earmarked for a reserved category candidate, he would be entitled to the benefits of consequential seniority as provided in the office memorandum dated so and so. But on the other hand, if the posts earmarked for the reserved category candidates are already exhausted by being occupied by reserved category candidates, but in the gradation list there remains some further reserved category candidates, they can compete for promotion against the unreserved posts. But in such event, they would not be entitled to the benefits of other benefits under the consequential seniority. So I will be entitled to promotion, but in the promoted cadre, I will not be entitled to get the benefit of consequential seniority. And on the other hand, if on the basis of their seniority otherwise, that is without taking note of the consequential seniority, they are within the zone of consideration, such candidates can be considered for promotion. So this has distinctly two parts. First part says that if I compete against the unreserved force, I will get the promotion, but not the benefit of consequential seniority. And the second part says that if I get the promotion on the basis of seniority alone, without taking into account the question of consequential seniority, then my case can be considered for promotion. So it no way, my lord, it gives a situation where it can be said that the 2002 office memorandum is inhibited by clause 4. Whereas the clause 4 was a total inhibition there, total prohibition. This has been clarified here. The reserved category candidate can compete for unreserved category of post. But after promotion, he will not be entitled to the benefit of consequential seniority, since he has once scored a consequential seniority in his career. but that does not prohibit me
No,
from
no, no, it
competing.
talks about without taking into consequential seniority, you
Now-
come into the zone of consideration.
No, therefore I said, Miller, there are two parts in this sentence. First part speaks about my eligibility to compete against the unreserved post. And if I compete and if I come out successful, I will not be entitled to get the benefit of consequential seniority in the promoted post.
I don't think that is little.
My lord, in my humble submission, my lord, that will be a interpretation which will be harmonious with
No,
the
no, no,
position.
no. You, if you read without taking in note of the consequential seniority.
So that is the second part.
Uh,
That is the second part. The second part speaks of a situation where I can, being a reserved category candidate, I can simply compete for unreserved category of post on the basis of my seniority alone. But in that circumstance, my consequential seniority will not come into play. Suppose without taking into consideration the case of my accelerated promotion earlier, on the basis of mere seniority, I can
that is what clause 4 says.
no, that clause 4 imposes a complete ban on me. Clause 4, if your lordship will kindly come to page 40, paragraph 44, clause 4 says that if the reserved category posts are filled up, then I have no chance. I can come only against reserved category of post and none and for none else. That is a complete prohibition. But this prohibition has been diluted in this paragraph, saying that even if the posts are filled up, I can compete against unreserved posts. And second,
No,
this
no,
is
clause 4 has two parts. Clause 4 has two parts.
clause 4 visualizes a situation, my lord, that the position of reserved category percentage is filled up. Then reserved category candidates remaining in the list will not be entitled to come unless they did not accept accelerated promotion.
That's right.
Unless they did accept accelerated promotion. The clarification given by the division bench goes a step further. It says that they can come, but they will not get the benefit of accelerated seniority in the promoted cadre.
Now this, no,
Kindly see the
that is all right. That is one part. Let us take it for the time being. What about the second part? Without taking note of their consequential seniority.
now this is a second proposition, my lord.
Uh,
It says that if simply on the basis of my seniority I come against the unreserved category of post, because the focus is on the unreserved category of post.
you come where? Within the zone of consideration.
Yes. If I can come within the zone of
But you have
consideration,
already got the benefit of accelerated promotion
no, in
earlier.
case, my lord, in the feeder cadre, my promotion was on merit. It was not on accelerated promotion. That's why I showed page 45 to your
No,
lordship.
no, may not be, but in one post, I think, what was that? Two posts.
Now,
Assistant
those-
engineer to assistant executive.
now, in that case, my lord, it has to be given an interpretation that the whole career prospect has to be opened up. That can never be the objective of the.
Otherwise, if you have to come within the zone of consideration without taking into the consequential seniority,
And on the other hand, if on the basis of their seniority otherwise,
let us say you got the accelerated promotion in
assistant executive engineer and executive engineer
executive engineer. Now in superintending engineer, it was by merit.
by merit.
Now, if obviously the question of accelerated seniority will not apply there.
No, it will not apply.
It will not apply there.
Therefore, I can compete against the unreserved category of posts based on my merit, in respect of which there was a prohibition in clause 4. And the second part of it, second part is a situation which will not come into play in this particular case because of the facts involved.
All right.
And another case, Miller, the BK Pavitra judgment that my learned friend has referred. All these judgments have been taken care of in a recent judgment, Miller, that is in 2020 11 SCC. There Sudhakar Babu Rao's case. I'll give the judgment also, 2020-11 SSC 399. Now, the argument made that since my accelerated promotions are in violation of the law laid down in Nagraj and all other judgment, and therefore sending the matter for review DPC will amount to reviving an illegality. Well, that will not hold good. In this particular case, exactly the similar fact situation in this case, the seniority lists were never challenged. And the Honorable Supreme Court has said that since the previous seniorities have remained undisturbed for whatever reason, on this context, a challenge will not be entertained. And in this judgment,
No, there is
all
no-
these cases,
There is no challenge also. right?
there is no challenge also. And that is the point. That this judgment, my lord, I'll submit the citation. I have to place the citation, my lord, copy I'll submit.
All right.
Huh?
What about the government?
This is. Well, we have filed affidavits. Apart from that, my lord, this is a too sensitive matter for me to traverse, my lord. Additional AG, my lord, he will address this court, my lord. And that part, my lord, I sail with the submissions of these senior counselor. He was denied promotion. He was not considered because he had he was bestowed the benefit of accelerated promotion at his career.
You adopt his arguments, then we close it.
Yes, I'm adopting his arguments. And apart from that, we had given affidavits.
Or is it a case that you want additional AG to argue the matter? Because this will have cascading effect. Either,
Perhaps lordship is correct. Let it be closed in his presence.
where is he now?
He has left the court. Let the matter come up on Monday.
Oh, wonderful. At least you
Because of
should
his
apprise,
justifications, my lord, I
at
want
least you
take
should
risk.
apprise additional AGs that hearings are being,
I had, my lord, he had another matter fixed. my lord.
are being carried on by the court.
Yes, my lord, no, he had some other matter. He was on legs. So, and apart from that, what has fallen from lordship, since this has a ramification, wide ramification, I won't take the risk, my lord.
Alright, in that case, my lord, if it is getting deferred, can it be Thursday, next Monday to Wednesday, I'm away.
বুধবারের রাত বুধবারে আহিব বুধবারে মানে 20 তারিখ
20 তারিখ।
I am informed by the court master, there are no dates available in September.
This should not take, I don't think they will take more than.
Provided he is available. I thought we could wrap it up today itself if he was available.
He will also.
Well, with the submission coming from him that he will adopt the line of argument of the private respondent. So the lordship can wrap it up even now.
I can wrap it up, but I think it is better to have his presence.
Yes, because it will have ramifications, wide ramifications.
In any case, it to support
We are keeping it on 5th October.
No, 5th is already.
My friend will be here with
You are not available. Give us your date,
no, your lordship can keep it on 5th.
5th or 10th?
5th, your lordship can keep it on 5th.
5th, all right. So for the hearing on 5th.
The lordship is keeping it parted.
Yes, you give us a list of the judgments that you're relying on. Both.
All right.
Yes.
Your lordship. Oh, we are for a respondent number 1, my lord. Actually, my lord, their matter has become infructuous because charge sheet has been submitted, my lord. Trial is going on, my lord.
Why the I was filed?
I expel my lord for
Cancellation of the anticipatory bail, my lord. Now, my lord, the case proceeded, my lord. Charge sheet has been submitted. The trial is being going on, my lord.
What is the status of the bail has been made absolute?
Yes, my lord. Now, my lord, trial is, charge sheet has been submitted, my lord. My lord, the charge sheet number
Already case 33, my lord.
Charge sheet number is, charge sheet number 216 oblique to 2023, my lord. Dated 17/6/23.
Page
33.
33. Yes. Why do you want cancellation?
After getting the bail, my lord, the accused has threatened the present applicant, my lord.
Have you filed any
Yes,
complaint?
FIR, I have also lodged an FIR, my lord. That your lordship will get that case 37, my lord.
What is the status of the FIR? Who's for the state PP? APP? Where's the APP? Let the APP come.
My lord.
Our lordship, my lord, we would like to file an additional
You file,
affidavit.
you file.
My lord, affidavit in opposition.
You file.
Annexing the charge sheet and everything, the relevant orders, my lord.
Whatever you want to file, you file in the IA.
My lord,
Yes.
so lordship may fix a date
Our
after 2
learned
weeks. my lord.
councils, APP for the state is not available, therefore the matter is deferred. Meanwhile, counsel for the opposite party is permitted to file their objections or affidavit. List after 2 weeks.
2 weeks. But can it be 3 weeks, my lord?
3 weeks? 3 weeks.
Obliged, my lord.
Wait, is your lordship? Lordship judgment dated 9/11/2018.
I have the updated instruction lordship. Matter is pending before the finance lordship.
Lordship, this request has been made couple of times, Lordship, in this matter. Couple of the contempt petitioners have already retired from the post, Lordship. Yeah. Last 3 occasions,
This is
Lordship,
the-
the same.
Latest communication, today's communication, 14.
What was the direction?
Page 28, my lord. Page 28. Paragraph 23. To direct the respondents to pay the petitioner basic scale of pay, including the arrears with effect from 22/1/2015 within 3 months. Thereafter, they came up with a proposal to pay a certain
Mr.
amount.
Gogoi, you'll have to expedite because
Lordship.
apparently you have gone beyond the date. You have not asked for extension of time also. 2018 matter.
Otherwise, also lordship, the matter is in the final stage, lordship. Just they have to sanction the.
Whatever it may be,
Lordship,
there is a
lordship.
direction for complying with the order within
Lordship,
3 months. And passed in 2018.
lordship,
We are beyond
lordship.
3 years, 4 years. Then there is no application seeking extension of time.
No,
You
no.
are unduly, you are taking undue advantage of liberty you are granted by the court. When can you get the sanction?
Lordship, it will come after 3 weeks, then in the
No,
meantime.
not
it will
3
be
weeks,
completed.
not 3 weeks, not 3 weeks. This is not done, otherwise we will be compelled to issue
Lordship.
notice. Notice has already been issued, we'll issue, we'll start proceedings under contempt. Mr. K. Gogoi, Learned Standing Counsel, Higher Education, has submitted before the court on the basis of instructions received that the matter is pending before the Finance Department for concurrence. Once the concurrence is obtained, the amount is directed by order dated so-and-so, passed in WPC so-and-so, can be released. Mr.
J. Singh, Lordship.
J. Singh appears for the petitioner. Submits that although the judgment of the court was rendered on 9/11/2018, and the direction was to comply with the order within a period of 3 months from the date of receipt of a certified copy of the order, and which certified copy was submitted by representation dated 14/11/2018, the order remains not complied with. Considering the submissions made by the learned counsels, we give further opportunity to the respondent to comply with the order. matter be listed after 2 weeks.
Lordship.
Not we are free for 60.
29th.
Next.
Twenty-one also, Lordship, it is pending views for before the finance, Lordship. That's because the petitioner is neither in the CPF, neither in the GPF, Lordship.
Whatever it is, comply with it.
Lordship. Now we are trying to give him, Lordship. Otherwise, his case is not covered for the pension, Lordship. So we are taking the views of the personal department as well as pension as well as finance, Lordship. It is pending for the finance.
None appears for the petitioner on call, Mr. K. Gugoi. So the respondent matter be listed after 2 weeks,
Oblige.
as Mr. Gugoi wants to complete his instructions.
Lordship.
Infractuous,
My lord, it is actually not in fact, that's it. What has happened, what had happened was, my lord, he was holding a quarter of the Central Reserve Police Force while he was serving in the Jammu and Kashmir, and when he was transferred to the Northeastern region, the office memorandum said that he could continue to hold the quarters without paying rent. Now, they wanted to evict the person, saying that he would not be allowed to continue. That is the time when we approached this honorable court. He continues to serve in the Northeastern region. They have filed an affidavit saying that for all the places, the maximum limit that one can hold a quarter is for 3 years or 5 years or 7 years with the approval of the DG. The office memorandum itself says that no time limit will be applicable when it is a posting either in the JK or in the left extremist area or in the Northeast. If they concede that yes, that clause will apply to me, then my lord, all that happens is I don't pay the rent and I continue to use the quarter till my posting in Northeast. They post me out of Northeast, I vacate the quarter. In case they say that I need to vacate the quarter, then my lord, we'll have to argue the matter. Otherwise, it will be a case of penal rent, which will be some 200, 300 times of the rent fixed.
yes.
Lordship, here, Lordship, the petitioner had occupying the quarter since 2001, Lordship. This petition is filed in the year 2000.
My lord, my permitter, I'll leave the case for the documents, then she can have an answer. We can have.
Sorry.
But if I leave the case on the basis of records, perhaps then she can argue on the basis of her affidavit. The matter can be then disposed of. Otherwise, I've just given a gist to show that it is not infractuous as such. I'll show those, my lord. If arguing the matter, then I'll have to first show, my lord, from the records that I am entitled to retaining.
Yes.
Lordship, but my submission is that Lordship from 2001, he is occupying the same quarter, Lordship. And as per on the out of the total strength, Lordship, quarter is less than the total strength of the CRPF personnel, Lordship. So from 2001 to he had filed this writ petition 2012 on the ground that both of his children are minor. One is reading in class 9 and one is reading in class 6. And second ground is that his wife is suffering for hypertension and mental nervous disorder. So
No, first tell us, he was posted where?
At present in Agartala.
No, at that time?
At that time,
I was posted at Jammu and Kashmir attached to Guwahati.
and during this
And where is the quarter?
in here in Guwahati.
At Guwahati. So you were in Guwahati from which date to which date?
My posting particulars I have given. In 2007, the battalion moved to Srinagar. Then in 2007, I was placed with the NES TAC headquarters. 2012, I was posted to 120th Battalion.
In Guwahati.
In Guwahati, and although the petitioner is transferred now to 120th Battalion, he has not been released from 49 Battalion yet.
Where is 49 Battalion?
49 Battalion is at Srinagar.
But you are attached to Guwahati?
Attached.
Okay.
That attachment is a temporary, when they give me some duty here.
Now,
Lordship says
your family, you're still occupying that quarter.
yes, because now I'm presently, in between I suffered 2 or 3 more transfers, all within the northeast. And then, right now I'm posted at Agartala.
And what
Which
is
is again in the
the
northeast.
policy for
That
allotment
lordship
and
will
vacation of
find-
quarters?
That lordship will find at page 25.
25.
It starts at page 25.
Hmm.
What they depend upon is at page 26, clause 4, subclause 4.
Page 26.
26, starts at page 25, the office memorandum. At page 26, clause 4, subclause 4, it says, family quarter will be allotted for a period of 3 years, or for the period of stay of allotee in the particular station, whichever is earlier. For this purpose, a waiting list of such personnel who are desirous to keep their families shall be maintained for each category separately, and allotment of quarter will be done strictly according to the priority in the waiting list. This is what they try to emphasize when they say that we have got a big waiting list and I should vacate my quarter
You are allotted for 3 years.
initially.
Hmm.
Now, if lordship will find at page 27, at page 27, clause 16.
27. 27.
Page 27, clause 16. These are the relevant clauses I'm reading out of.
There is no 16 in 27.
The two lordships, right, my lord, it is in 2 pages.
Then it will be 28. Sorry, not 28.
Last one.
Yes. Okay.
After expiry of the prescribed period, the allotee shall be required to vacate the quarter subject to exception laid down unless decided otherwise by the HMC for reasons to be recorded in writing.
What is HMC?
Then lordship will have.
What is HMC?
Each of the Housing Management Committee. Then at page 28, some clauses are given,
Hmm.
which say family members suffering from chronic disease till cured and recommended by the medical board. Then family members required to be operated upon or recently operated upon delivery cases and education of children. This is what they try to say, that when I took the ground of my children studying, they said education of children till the closing of the current academic session is what I was entitled to. Now, lordship would kindly have page 29, clause 25. This they do not read. The maximum retention of a period of quarter is prescribed as 5 years, with the provision that even after posting to attached battalions of the group center, the retention period will not be extended beyond 5 years in any case. The periodicity of 5 years retention of CRPF accommodation should not be made applicable to personnel posted to Northeast region and JNK exclusively for the period they remain posted in Northeast region and JNK as per GOI orders. However, 5 years of occupation period shall be counted from the date of original allotment of such accommodation on return from any or JK region. They post me from JK region to the Northeast region, continue to keep me in the Northeast region. And therefore, the periodicity of 5 years will not be applicable to me. I will retain it till I am posted either in the Northeast or in the JK. This underwent a modification that lordship would find at page 31. Starts at page 31.
Okay.
And at page 32, clause D. Maximum retention period of 5 years on posting to Jammu and Kashmir or the Northeast region or the left wing extremist area as per Rule 525 of CRPF Family Accommodation Rules 2018 is withdrawn, and all such personnel shall be allowed to retain the family quarter till their actual posting in these areas. Only case of the petitioner is keep me
Is still
posted in the Northeast or in the JK or in the LWE, I retain the quarter. Move me out of there, I vacate the quarter. As easy as that.
Lordship, let me submit lordship. Here, lordship, first thing is that lordship, that ground that his children, they are around, perhaps they had themselves had now posted in service lordship. They are 25, 26 around that of age lordship. And his wife, that is also a ground in the writ petition. She is suffering at that time from pressure, hypertension and nervous disorder. So apart from that lordship, what is that lordship? He is occupying the quarter for 23 years. He is a resident of Moriani Jorhat lordship. So lordship, we have a less amount of quarter in compared to the
That's
official
all right, but
lordship.
your rules say very categorically.
Yes, lordship, now he is posted in Agartala. So he can ask for a quarter in Agartala lordship. Apart from
The question
staying
is of
here
retention,
lordship.
my lord. The rules say retention. I retain the quarter.
Notice Agartala is
Let them
there
give me a
lordship.
quarter at Agartala. I'll move.
Yes, lordship, he can
I will not ask.
definitely
It's a
get,
question of retention.
there is not, he can apply for a quarter in Agartala. Now his children are majors and his wife can stay there lordship. And even lordship, he is retaining the quarter for 23 years. There is provision that he can ask
You
for
apply.
HRA.
My lord,
You apply.
the issue is one of retention.
Huh?
The rules say I will retain the quarter here.
That's
The
right.
rules do not say that I will need to apply and go there.
No, you will retain,
Yes. I
but
retain it.
the retention has to be ordinarily in your place of posting,
Yes,
My lord, that is why
which
it
is in the
said that-
northeast.
My lord, that is what it is said. That is why they say that when I am posted in the northeast or in the JK, because of the lack of quarters in all the other locations,
All
whatever I
understood,
hit, I
all
retain.
understood,
My
but
lord.
if there are quarters available,
My lord.
what is your difficulty
If
in,
there is a quarter available, I can go.
so that,
I'll apply. No difficulty in applying, my lord. But
So-
if they cannot give me an accommodation in Agartala,
then you'll retain it.
then I can continue to retain. That
and
is,
there is also
that is
provision that he can ask for HRA lordship because others are also
No,
waiting in the list
No,
lordship.
no.
And the
If
transfer
you give him a quarter in Agartala, he'll vacate it.
lordship.
So will you
Let
give
him
him,
submit a representation lordship.
why don't you give him a quarter in Agartala without a representation? You tell
Let
him.
at least he has to approach lordship. He has
He
not
does not have
approached.
to. You are asking him to vacate.
Yes, lordship.
You tell him that in terms of this provision, please proceed to Agartala in so and so quarter and vacate this quarter within such and such day. You will give you that liberty.
Lordship. Lordship may fix it on Tuesday, lordship, just I can obtain that instruction, lordship.
All right.
I would not be here on Tuesday, couldn't be Wednesday. Just to hear.
All right, Wednesday.
List on so and so date of the request
Tuesday.
witness.
Let it be 19th, my lord, Tuesday.
We don't know. Kun tarike tu?
Can be on 19th.
19th, all right.
Lordship.
B. Sharma for instructions, Mr. R. Mazumdar appeals for petition. Yes, 19th, list on 19th.
Obliged.
Yes.
Here, lordship, they had challenged the promotion of private respondent, but office note states that they had not taken steps, lordship. And it's last listed on 2017, thereafter not listed also. Senior counsel had expired, but there are two other counsels are also there.
Office note dated 01/2016 shows that steps on respondent 4 has not been effected. The matter was listed last on 23/2/2017. None appears for the petitioner on call. MSP Sharma appears for the respondent. Registry to verify on the service of notice on respondent 4 and the matter be listed thereafter.
Lordship, steps not taken, that is there.
No.
Ah.
Maybe anyone might have taken steps. This is a notice. This is a note of 2016.
Yes, lordship,
Thereafter,
in between, lordship.
office to verify if steps have been taken pursuant subsequent to the earlier office note and make necessary endorsements and place it before the court within 1 week from today.
Obliged.
Yes.
This is a case of promotion. Earlier, writ petition has been filed by the writ petitioner, my lord, that is page 8.
Hmm?
Page 8, para 17, my lord.
Earlier writ petition?
Earlier, writ petition is
No,
page
but
8.
there's nobody appears.
Yes, my lord.
None appears for the petitioner on call. Let me see that the respondent matter passed over for the day. Yes. Willful absence.
My lord.
We'll have it on some other day. List on. Give it.
মাজত মাথাটো সেইকাৰণে
26, 28.
yes
28,
26 28 is okay.
Yes. Yes, Mr. Chakraborty.
Termination of service, my lord, during the termination of service, during the period of probation, my lord, the order has been stayed by the honorable court. Because there was no inquiry before that, my lord. I was appointed as a junior engineer in grade. My service has been terminated on the ground that at the time of appointment, I have suppressed the fact that a criminal case was pending against me. My whole case is that from the documents I have improved, my lord, will show that I had no knowledge about the pendency of the case. My lord. It was a petty case pending against me, my lord. Quarrel with the neighbor, my lord,
What case? Criminal matter
criminal matter.
pending against you.
Against
And what happened? You were taken
when
into
I was
custody.
appointed, I had to give some declaration, and allegation is that I have suppressed this fact, having due knowledge about it,
About that criminal case.
about the criminal case. It was a case given by my neighbor, my lord. Finally, I have been acquitted. The complainant all have said that there was nothing against me, my lord. So my basic case is that, my lord, first thing from the record, I show that I had no knowledge about this, my lord. Only when I came to know about the police verification,
It is what case? It's a pursuant to an FIR or a complaint matter.
Yes, lordship.
pursuant to an FIR, my lord. Bailable, my lord, offense, my lord.
Then when did the trial proceed?
I was, my lord, appointed. I have prepared a date chart, my lord, lordship. It was- The Honorable Supreme Court has given a detailed guideline, my lord. In such situation, what steps should be? In Avtar Singh's cases, my lord, there were numerous cases earlier by a full bench. The Avtar Singh case, my lord, a guideline has been given, my lord. My second limb of argument is that, and even if assuming that I suppress this fact, my lord, they have not followed the procedure. They have not considered the due things while issuing the notice of termination. Now,
In the charge sheet that was filed,
charge sheet, there was no charge sheet, my lord. I was in probation, my lord.
no, you said charge sheet was filed?
No. Charge sheet in the criminal case. Yes, my lord.
Charge sheet was filed.
Charge sheet was filed.
So in the charge hearing, you were not there.
I was not there, my lord. My entire family members were, they all of us, when sections were all bailable, my lord.
Where is that charge?
Yes, my lord. Charge is, my lord,
Framing of charges.
page
order?
18, my lord.
Page
18, 1-8.
1-8. This is the charge sheet. The order framing charges?
I'm coming now. Yes, my lord. Here's the charge sheet, my lord, Charges were-
Where is the order framing charges
by the magistrate.
by the minister?
That is not there, my lord. That is not there, but I have given a date chart. Lakshmi, kindly
No,
see.
but that will reveal whether you are present or not before that court.
Lordship may kindly take up my affidavit where is the judgment and judgment,
Judgment, I have enclosed, my lord. I'll come to that, my lord. But 102, Lakshmi, kindly see. I have given the detailed date chart, my lord.
They have seen-
Regarding the criminal case proceeding, my lord.
Yes,
102.
yes.
Has your lordship got it? 102.
102,
102. My affidavit didn't reply, my lord.
yes. Yes,
My lord, on 10th of December 2014, charge sheet filed by the police before the court. 16/6/2015, summons were issued to the accused person. 21st of September, accused absent, press summons issued, my lord. 6th of January 2016, accused absent. 22nd of April 14, accused absent, bailable warrant of arrest was issued. 16th of June 2016, accused absent, bailable again issued, my lord. 2/8/2016, accused Vinod is my father, my lord. Raj Narayan, Ganpati appeared and granted bail. Just after 2 days, my lord. Just after 2 days, I appeared and I got bail, my lord. When we came to know in the proof verification stage, my lord, that the case is pending, my lord, we have come and along with all other accused person, we have taken bail within 2 days, my lord. I was that time I was serving. When I came to know, I made an inquiry and I have taken bail on that date, my lord.
you produce the charge order, framing of charge order.
Pending of charge order.
You get it?
That order, it is given, my lord.
Where?
No, this date, lordship, kindly see, after 10,
It doesn't reflect when the charges were framed.
no, that 22nd of April and all these, my lord, accused are absent, my lord. They were not,
No, this is
my lord,
okay.
bailable warrant of issue, is issued only when after they appear, then charges were framed.
That is what we want to, it is not reflected here.
Summons issued to the witnesses, summons issued to the witnesses, between one was examined, all dates are given, my lord.
Then the framing of charges framed was not here.
On, my lord, 4th of August 2016, I appeared. Just 2 days prior to that, on 2nd of August, my other family members, they have taken.
We have seen that. But you see, after charge sheet being filed, summons issued, you are absent. Bailable warrant issued.
Yes, my lord.
So after you were granted bail, then again, the summons issued to witness, so and so examine statement under 313 judgment.
Yes, my lord.
Now, it could not have been done without framing of charges.
Yes, ma'am. Charges must have been paid, madam.
Has to be.
In the presence of witness.
So let us see that order. That will reflect if you are present, you are present. If you're not there, you're not there.
Madam, if that is.
That will reflect everything.
If lordship,
Whether you are aware of the
Charge.
tendency of the case or not.
ma'am, I have given category, they have not disputed this, my lord. Only when I came to know me and my family members.
That is what we want to find out.
Exactly.
If in the charge hearing you are not there, it was framed in your absence.
My lord,
You are treated to be an absconder or something like that. Where is the charge sheet again?
charge sheet, my lord, that
page 18.
1/8, madam.
118.
1/8 of my
118.
petition. And lordship comes to the judgment, my lord. Judgment that from there, my lord, all these complainants, informant, my lord, they have categorically said, my lord, they have filed this FIR only on the basis of the villagers saying, my lord, they have nothing to say against us. My lord. All the complainants have said, my lord. On that basis, my lord, we were all acquitted. And charges, my lord, 323, 504 and 506, all bailable offences. Only one charge, my lord, 542, 542 was a serious charge which was there in the FIR. But police in the charge sheet, Lordship, it is mentioned in page 18, my lord. And Lordship may kindly see, in spite thereof, that they are aware of the judgment, my lord, they have passed this notice of termination on the basis of 452, saying that I have suppressed this fact. 452 was never a charge, my lord. The termination order has been issued because 452 is a serious charge, my lord. And others are all bailable offenses.
Where is the termination order?
Termination, notice of termination, page 48, my lord.
Where does one find the grounds of termination?
89, my lord. They have enclosed it, my lord.
89.
89. It is on the basis of 452, my lord. Again, 452, they have clarified twice whether 452 is not there. Police has clarified twice that 452 was not there in the charge. In spite thereof, in the termination order, they mentioned about 452, my lord. This is the reason which was there in the record, they have enclosed, my lord. Paragraph 3, my lord. Page 36, your lordship will find, my lord, prior to that, they had clarification whether 452 was there or not. It has been clarified by the police that 452 was not there.
Where is the judgment?
Judgment of the court, my lord? Yes. 26, my lord. Lordship may read from 27, last one, my lord. PW1, please file the FIR, my lord. Meena stated in examination in chief that on the informant was at her home. Before that, there was little bit of argument. 27. Last paragraph, 27. Evidence. Between informant and so-and-so, wife of so-and-so. The argument was already over. But Gyanvati called her husband Binod, son of so-and-so, to mobile, and her son Dhananjay. Dhananjay is the petitioner, my lord, and so-and-so started narrating false story with exaggeration, and after that, Gyanvati, Vinod, Dhananjay, and so-and-so entered into the informant's house, and by hearing hue and cry of them, the neighbors of the locality rushed in the. It was dark night, and there was no light in the same time. One pushed me behind my back. I fell down and got hurt. Accused Vinod, Dhananjay, and Gyanvati neither beaten me nor my brother and sister, and not used any slang words against us, and threatened us to kill us. I have filed the FIR on the instigation of the villagers. Then PW2 also said the same thing, my lord. Dhananjay neither beaten me nor my brother, sister, nor used any slang words against me. PW3, my lord, did not beat the informant so-and-so, my lord. So on the basis of this, my lord, we were acquitted, my lord. PW4 also, my lord. Accused Dhananjay, so-and-so, neither beaten me nor my brother or sister, nor used any slang word against me, not threatened, my lord. And if your lordship goes through the guidelines which has been given by the Supreme Court, my lord. Because separation of a criminal case, in many cases, Supreme Court passed different judgment, my lord, conflicting judgment. So it went to the full bench, and full bench has considered all the judgment and has given a detailed guideline.
Where is it?
My lord. As a court judgment, I'll be requiring on different aspect, my lord. Relying Dhananjay, recent judgment has been passed, my lord, which is appropriate to our case, my lord. The facts are same almost. Para 27, Lordship may kindly consider, my lord.
Of,
Dhananjay, my lord, 2016 8 SCC.
After Singh.
After Singh.
para
Para 27, my lord.
27.
Before that, my lord, court has considered all the judgments, my lord.
Hmm.
Lordship will find on this point which were conflicting in nature.
Yes, para 27.
27, my lord. May I read it?
No, 27 is basically laying consideration of all the judgments.
Yes, sir. From that, they are considering the judgment. Finally, the guideline is, Lordship, my lord.
Hmm.
They are 38, my lord.
38.
Ratio is 29
Yes.
and 39 is.
Yes.
Yes, my lord. My lord, earlier paragraphs are also relevant, my lord. Timing, I can read it, but earlier some 2-3 paragraphs I have to read from the backside, my lord. While laying down the ratio, my lord. 38, I may read, my lord. We have noticed various decisions and tried to explain to reconcile them as far as possible. In view of the effort of the decision, we summarize our conclusions as follows, my lord. Information given to the employer by a candidate as to conviction, acquittal or arrest or pendency of a criminal case, whether before or after entering into service, must be true, and there should be no suppression or false mention or of required information. While passing the order of termination of services or cancellation of candidature or giving false information, the employer may take notice of special circumstances of the case, if any, while giving such information. The employer shall take into
It's
consideration
come
the
to 38.4.3.
4.3, my lord. If acquittal has already been recorded in a case involving moral turpitude, my lord, or offense of heinous serious nature, my lord, or technical ground, and it is not a case of clean acquittal or benefit of reasonable doubt has been given, the employer may consider all relevant facts available to the antecedent and may take appropriate decision as to the continuation of the employee. This exercise has not been done, my lord. What is the nature? What is my age? What is the nature of time? My case is the first thing first, my lord, I had no knowledge, my lord. That has been mentioned in the subsequently, my lord.
So that knowledge factor we want to see from that order framing charge.
I'll produce that, my
They
lord.
produce it.
I'll produce it. First thing,
Once we cross the first hurdle, that
Madam.
yes, you are indeed not aware of a case,
that I'll, some time may be given, my lord. He is posted in Jammu Kashmir, my lord. Some time may be required.
then we'll take it up when you produce that record.
Lordship, he is on enjoying a stay from 2017, Lordship.
You
And
produce that order framing charge.
Lordship,
We'll go
one
through.
thing I must submit, Lordship, that framing of such, perhaps, Lordship, whether he had, let us assume that my learned senior's argument that he was not aware, but subsequently he came to know about those, but thereafter also he had not taken any step to
He was
intimate.
acquitted,
Lordship, I have stated in my affidavit all those
but
things,
he was acquitted.
but benefit on doubt, Lordship.
What
Others,
benefit of doubt?
yes, Lordship, judgment is there, Lordship. It's only on benefit and doubt.
Lordship, I've given one judgment, my lord, here.
Page 29 of
In
read
the
petition,
judgment,
Lordship.
my lord, after recording all this in the judgment, in the last part it is mentioned benefit of doubt. I've given one judgment, my lord, says that whether it is a clean acquittal or benefit, Lordship, the entire judgment has to be read. That Bombay High Court judgment I have given, my lord. From the judgment, it will appear, my lord, reading the judgment, it was a benefit of doubt or it was a clean acquittal.
What was your case?
My lord,
How have we acquitted? Benefit
Here.
of doubt.
Page
In
29.
your case,
no, I have read the evidence, my lord. On the basis of that, the judgment has been given. Last, there is a line mentioned.
no, in your case, what is the acquittal order?
Page 29, Lordship, of the read petition.
Hmm.
That I've read, my lord. judge has mentioned last line benefit of doubt, my lord. But if your lordship reads the entire judgment, my lord, entire prosecution witnesses state that there is nothing against me, my lord. So that's why this Bombay High Court judgment I have placed before lordship, my lord, while considering an acquittal, whether it's benefit of doubt or clean acquittal, my lord, the judgment, entire judgment has to be read, my lord. The Bombay High Court has been passed relying on Supreme Court judgment, my lord. That I have furnished before lordship, my lord.
Yes.
And that guideline, last part is mentioned that if there was no knowledge, my lord, that has to be different footing, my lord. So as the lordship pointed out, my lord, that charge, framing of charge by the magistrate, I'll produce that, my lord.
All right, we'll hear it again. You, let us first understand your charge order.
My lord.
Yes. You produce the charge order, let us.
My lord, my lord.
Lordship, perhaps it is disposed in the year 2016, Lordship, and it is from UP Ghasi police station. So whether it will be
He
available
has
or
it.
not,
He says
but
he'll
he
produce
will
it.
take time again and again, Lordship, from 2017. Lordship,
Exemption and presumption is there. I'll try
no,
my
Lordship,
best, my lord.
Lordship may kindly go through the order sheet. It reflects what,
We will take it up. We
How
are not
much
giving
time?
him very elongated time. Take it up on
so
within
Lordship
1
will
week.
kindly fix, perhaps it will not be possible before vacation. So immediately after vacation, so that they,
Why are you presuming not before vacation?
because I have seen the last 7-8 years, Lordship, how much time I have mentioned this matter only, I know that. And
We will fix it. You tell us a date. We'll fix it.
2 weeks he may not be able to, because I said it's from not only UP Ghasi. I don't know whether it will be available or not, Lordship. So immediately in the month of November reopening, sufficient time should be given to him so that no further time.
It's a reasonable thing, my lord. I agree to hard, my lord.
All right. Second.
I cannot take much
2nd of
time, my lord.
November.
17,
No,
my lord.
now it is up to 5th holiday.
Oh, sorry. এখন বদলাই কিয় দিয়া নাই? Sorry. 9th November.
Lordship. Lordship.
9th of
November.
Right.
Matter be listed again on 9 November, enabling the learned counsel to the petitioner to place before the court the order framing charge against the
In the criminal
petitioner
case.
in the criminal matter which was pending at the relevant point in time. MSB Devi Sharma appears for the respondent. 9 November,
Gotcha.
based on 9 November.
Okay.
May I please, Lordship? I am sorry to mention that the Lordship, item number 21, we were dear, Lordship, we are waiting, but it is running 13, Lordship.
Hmm?
So non-equal for the petition is written, kindly, Lordship, it may be, our name may be recorded.
All right, passed over. We'll pass it over. Don't worry.
No, or non-equal for the petitioner is written.
Because none had appeared, what to do?
Not, it is not reach serially.
Huh?
It is not, we thought that it will go serially, Lordship.
It is reflected what items are taken up on the notice board. All right,
BC
item number
Item number 21.
21. All right.
BC Dakar, Lordship, for
Mr. So-and-so had.
for the petition. BC Dakar
Yes.
for the. Thank you,
Okay.
Lordship.
Herein, my lord, on the last occasion, direction given to produce all the relevant records regarding the disciplinary proceeding of other incumbents. My lord, I am challenging the parity of penalty regarding the petition. Altogether, there are 8 persons, my lord. Except me, all are reinstated or somewhere given the benefit of compulsory retirement. Somewhere given the penalty of stoppage of increment like this.
What was that police?
Yes,
Is it
yes.
the police?
Yes. For disgusting.
Yes, who's appearing for the respondents?
Lordship. No, original records, we have some received some records.
Huh?
The original records we have received, Lordship. Can it be on next week, Lordship?
We don't know. Give a date. Learned counsel for the respondent submits that reports have been received. However, it requires further time to complete
22nd.
to complete his instructions. This on 22nd.
22nd is motion day, my lord.
Did you? I think 5th of October.
Lovely.
Yes, Mr. Goswami.
Well, this is a matter, my lord. It is challenging an order of termination and at the same time also praying for direction, my lord, for payment of service, unpaid service benefits to the petitioner. Your lordship, I had prepared a list of dates if your lordship would like to.
Will require some hearing.
Will request something.
We'll keep it for some day.
Actually, matter is pending for quite some time, my lord.
Any records are necessary?
Yes, my lord. We have got the records, my lord.
What is the
Take to the convenience of the court, pray for a early day of hearing. Actually, it was in the hearing list for last several months, my lord, if I may say, my lord. But then initially the respondent side had said that records are with them, and then they said the file is missing. And then luckily, my lord, this time, my lord, the records are there.
you were placed under suspension? Were you placed under suspension?
In 86, man, in 89, my lord.
Then what happened?
And then I was reinstated.
Reinstated.
Yes, my lord.
Then
And
inquiry
second-
proceeded.
In 2000, my lord, I had joined.
Inquiry submitted. Inquiry report.
Yes. There
Then
were
what
some,
happened?
penalties imposed on me, but.
What is the penalty?
My lord, the stoppage of increments,
Uh,
for 3 years.
uh,
And the issue is something else, my lord. Actually, I had gone after my reinstatement and I had joined, but I was not handed over the charge. Because the order didn't reflect there was no clear direction asking the incumbent at that place of posting to hand over charge to me. So the charge was not handed over to me. And therefore I remained without charge and I had joined, submitted that is accepted. They accepted my joining. And thereafter I had.
you're praying for setting aside of the departmental proceeding and the impugned order for removing you from service.
Yes, that happened in 2018.
Ah.
That is the second DP. There were 2 DPs. First one, my lord,
So in
that
this
order,
writ petition, this is your prayer.
my lord.
In this writ petition, this is your prayer.
Yes, ma'am.
So we are concerned with only the DP concluded on the
On
DP
2018. ma'am.
leading to your order of removal on 3007/2018.
No, my lord.
Page number 28.
Your lordship, there is, my lord, this is.
Your prayer at page number 28.
Yes, my lord. Yes, my lord. That is a prayer.
Then, and for
Annexure 23, my lord.
for reinstating you.
For
Now-
reinstating, my lord.
Why are you challenging the DP?
My lord, because, my lord, I was not heard, my lord. Lack of opportunity, my lord. This isn't very short, my lord. This just a note, my lord. But issue is this, my lord. I was not posted. No order was passed for posting me, my lord. And the initial order that didn't specify, my lord, that the charge should be handed over to me, for which the incumbent already working there didn't hand over charge to me. And I remained without posting all these years. And then they held that after you had submitted your joining letter, you did never report for duty.
Where is
So,
the order of termination?
my lord, that is annexure 23.
Page number.
Page number 82. It's a very short order. May I read, my
removed from service.
Yes, I was removed from service.
Very well.
They say, my lord, that I did not take your lordship, my lord, kindly note, my lord, that I didn't take any serious steps to intimate the authority. What more can I do except writing to them, my lord?
Where are your statement of allegations or charges? What are the
So-
allegations?
My lord, I don't know. Still, huh?
Page 54, my lord.
My lord. Statement of allegations, page 55. Basically, two allegations, my lord.
At the time of suspension, you were posted where in that same Bokajan.
Yes, Bokazan. Bokazan was the only and the one posting, my lord, after the reinstatement. But the order did not specify, my lord, to hand over charge to me. And that is why charge was not handed over to me. And not only then thereafter, my lord, even though I had, my lord, intimated, they did never pass any specific order.
All right, we'll hear it on some other day. Keep the records available. A list on
An early date, my lord, because they
5th November,
5th of October.
October,
October.
5th of October. For hearing, the learned counsel, Mr. Bora, will keep the relevant records pertaining to the disciplinary inquiry and other connected records.
And the records from the Karbi Anglong Autonomous Council.
What records? Who conducted the disciplinary proceeding?
Disciplinary proceeding was conducted by the health department. The issue is, my lord, because allegation that he just joined there and did not take over, sir. That is the issue, my lord.
So those will be available in your records?
Yes, my lord. That is
Then why,
available in my record.
what further
But,
records are necessary?
because this is the transferred subject to the Karbi Anglong Autonomous Council, my lord. So they are they have also got their records, my lord.
Disciplinary proceeding records are with whom?
Yes, that is with
So
me.
that will do for
But
the
on
time being.
last occasion, my lord, this honorable court was pleased to direct the Karbi Anglong Autonomous Council authorities to produce their
What records do you have
whether
pertaining to the petitioner?
he has taken over charge or not, that is with
So without that record, how did you conduct the DP?
my lord. The statement of the concerned joint director, concerned superintendent, that is with me, my lord.
You get the entire records
Yes,
on the
my lord,
basis.
that is-
Your allegation is he did not assume his responsibilities after being reinstated.
Yes, my lord.
So pursuant to that, you initiated a departmental proceeding.
Yes, my lord.
Now, while you were doing it, are you telling us that you don't have the relevant records to see whether he went and joined?
No, my lord, I have got the relevant record.
That will do.
Yes, sir.
Let us see. List again on we said 5th October.
And another issue is, my lord, even the admitted amounts also have not been paid to me till date.
We'll see that.
Yes.
Records we kept relevant. Relevant records we kept.
Much obliged.
Yes.
Lordship, my senior is on legs at court number 12.
Yes.
It's a matter relating to dismissal from service. So it requires some hearing on this matter. Because one of my allegation is that the inquiry officer, the discipline authority acted as a presenting officer in the whole.
All right, list next week. 21 matter, okay.
Lordship, after 26.
Hmm?
After 26.
Why?
He will be out of station.
Tenth October.
Recording.
10th October.
Patrick Lawson. This case, my lord, in 2002, my lord, disciplinary proceeding was initiated against the petitioner lordship. He was also, my lord, booked into a criminal case, my lord, for allegation of offense under section 302. In that case, he was, my lord, acquitted. And this departmental proceeding, my lord, imposed punishment, my lord, in proceeding lordship. Dismissal from service lordship. The Honorable High Court, my lord, in a case lordship, set aside the, my lord, that order of the disciplinary proceeding lordship and directed to, my lord, reimpose the, my lord, punishment, my lord, on the charge of, my lord, misbehaving, my lord, senior officer lordship. My lord, the senior officer, my lord, sorry, thereafter, my lord, that order was not complied with for 1 year lordship. I approached the authorities to allow me to join in service lordship. I was not allowed to join, my lord, after 1 year lordship of passing this order to avoid, my lord, contempt. My writ appeal was filed, my lord. The Honorable Court, my lord, while admitting the writ appeal, my lord, they declined to, my lord, pass an interim order lordship, my lord, to stay the judgment lordship. Then, my lord, thereafter also I was not allowed to join lordship.
Then writ appeal was dismissed.
That appeal was dismissed lordship. Now, my lord, the authority has, my lord, passed order lordship, my lord, withholding increments, my lord, 3 increments, my lord, with cumulative effect lordship. And that is against the against rule 72 of the CRPF rules, my lord. My lord, CRPF rule says only 1 year it can be, my lord, imposed. That is for 3 years lordship, with that too with cumulative effect lordship. Now, another aspect lordship, despite the order of the departmental authority was set aside, my lord, I was not allowed to join lordship. Thereafter, subsequent order by separate order lordship, my lord, I was informed that this salary cannot be paid lordship, that during the period which, my lord, had been regularized lordship, the absent period lordship. My lord, absent was not for my default lord. That means I was having, my lord, a right, my lord, under as per order of the Honorable High Court lordship. That was not complied with lordship. During that period lordship, my salary has not been paid. So now, page 36, the order. Initial order of the disciplinary proceeding lordship. Page 36. This is what this was interfered with.
Where is the impugned order?
Impugned order was at this lordship, page 65. Lordship.
Why do you say this is, you say this is contrary to rules?
Yes, lordship.
Why? Which
Rule
rules?
72 lordship of the CRPF rules,
CRPF rules.
my lord. Rule 72 lordship, withholding of increment. Married lordship. Withholding 72. Married lordship. If the increment of a member of the force is withheld, the period for which it is withheld
Beyond, not beyond 1 year.
1 year lordship, but it is for 3 years.
Yes.
This matter has been settled by this honorable court, madam. Sorry, madam. There are 2 cases, madam, on this issue. It's a fact that, madam, under Rule 72, madam, we cannot have stopped his increment for more than 1 year, madam. That is a fact. That's been settled by this honorable court also, madam. There are two judgments, my lord. I think my friend has not come up with those judgments, my lord. The one is of 2018, my lord, Rahul Kumar's case. And based on that case, my lord, the another case, Sukram's case has been decided to 2021. My lord,
What effect?
Yes. Here, what happened, my lord, he similarly situated, because my lord, what happened? 3 years period has gone. So, my lord, but so far the cumulative effect is concerned, my lord, will remain, this will affect even his pension and other benefits, my lord. So, my lord, in this case, Sukram's case, my lord, that cumulative effect has been, my lord, set aside. So this is judgment, my lord, which is in his favor.
Of this court?
Yes, ma'am. Single, coordinate bench, my lord. Well, I have got it from the website, my lord. Also, may kindly come to para 11, my lord. That is the operative part. After discussing Rahul Kumar's case, my lord, this direction is passed.
No, but then you'll have to give back the, you have stopped his increments
Yes,
for
ma'am.
3 years.
Yes.
So that is entitled to now.
My lord.
He's entitled to that because it is it's contrary to the rules.
Yes, my lord. Because rule 72 says only for 1 year. It cannot exceed 1 year. That's true. And there's no problem. Even, my lord, the table appended to rule 27, serial number 7. So we kindly come to rule 27, my lord. There's a provision for stoppage of increment.
Increment, not increments, lordship.
Yes, but the period has not been specified, my lord. Rule 27, my lord. Serial number 7 of the table, my lord. Stoppage of increment is there, my lord, but period has not been specified. The period has been specified only in rule 72. That is 1 year.
But
There's no provision for cumulative effect also. That's true, madam.
Then the punishment imposed is?
my lord, punishment imposed is lordship, stoppage of, my lord, increment
For 3 years.
for 3 years with cumulative effect, lordship. My lord, rule 27, serial number 7 does not say. My lord, it speaks, my lord, about increment, single number, my lord. Cumulative effect is absent, lordship. My lord, only one increment is permitted under this rule. Other is absent, lordship.
Here there is a reduction of pay.
My lord, this is a
by 2 stages.
stoppage Reduction of pay. My
66.
lord, it's affects is my lord stoppage lordship.
What is the punishment imposed on you?
This is reduction of pay by 2 stages in time scale of pay in the revised pay scale of corresponding pay scale of rupees so and so for a period of 3 years with cumulative effect. Cumulative effect, my lord, is not not there in the rule lordship.
Hmm. And then you will not
My
earn
lord,
increments also.
Lordship. Cumulative effect, my lord, forever lordship. It will not be restored.
What is the punishment again? As per the rules,
Well, as per the rules, lordship, the
what are the
Section-
punishments?
Malad, Lordship may kindly come to section 11 of the Act. Malad. There's a
11.
minor punishment has been prescribed.
Hmm.
There are 5, my lord. Reduction in rank, fine of any amount not exceeding 1 month's pay and allowance, confinement to quarters, lines or camps for a term not exceeding one month, confinement in the quarter guard for not more than 28 days, with or without punishment, drill or extra guard, fatigue or other duty, and removal from any office of distinction or special emolument in the force. Well, this is the punishment prescribed for minor offense.
and reduction, my lord, this is the only, my lord,
In rank,
my lord, in rank, lord. Reduction is pay, or pay is not there, lord.
is not there.
And what is in 27? Rule 27?
27, my lord, increments, lordship. Only one increment about
Stoppage of increment.
stoppage of increment, lordship.
No, rule 27.
Yes,
Rule 27 is the procedural lordship.
for avoiding punishment.
My lord. Procedure for the award of punishment, lord. Number 1, dismissal from service. My lord, who will pass order of punishment, lordship?
Where are the major punishments?
This is major punishment, cumulative, my lord. This is,
Where are the major punishments under the Act?
my lord, the rule 10, lordship.
Rule 9, my lord.
9 and
Section 9.
Section 9 and 10, lord. My lord, section 9 is my lord, more heinous offense. 10 is my lord, less heinous offense. And my other is my lord, 11 is minor punishments.
Why do you say that the punishment under this minor punishment, there is no reduction in pay?
Well, yes, reduction in pay, lordship, but it, number 1 punishment, lordship, section 11.
That is in rank.
This is reduction in rank, but it's not pay, lordship.
Then come to pay, rule 27.
Rule 27, lord.
Serial number 2, my lord.
It is there.
My lord, it is there, lordship. Reduction to a lower time scale of pay. My lord, that is without any, my lord, cumulative, nothing has been stated about cumulative of 4 2 years.
Cumulative effect is one part,
Yes.
whether reduction is there or not.
It is there, lordship, too.
So you are not agreed by the reduction of pay.
And reduction, my lord, that is,
You are agreed by the cumulative effect.
yes, lordship. Cumulative effect, my lord, for 3 years, my lord,
And as per 27, it is for 1 year.
my lord, increment 1 year, lordship. Only one
72.
increment, lord.
70.
72.
2 is the reduction. My lord, 7 is the, my lord, 1 increment. On merit, my lord, it is not a gross misconduct, lord.
Yes.
My lord,
What is your prayer?
Prayer is Lordship to set aside the order, Lordship. So far the increments, purpose of reduction of increment, Lordship, sorry.
What is your prayer now?
Well, that may be set aside, Lordship.
What may be set aside?
The order, that part on the important part, Lordship. Important part of the order. At page 65.
You make up your mind and
Paragraph 8.
you make up your mind and come back again on Friday. Friday.
Lordship.
You understand what you want and then make your submissions. Your prayer when the writ petition was filed was different.
Yes.
And what do you want today? You make up your mind, come back on
If it is
Friday.
the proposal. If this clause 8 is.
No, you come back
Yes, Lord.
and tell us
Lordship.
what you want on Friday. Yes.
Lordship. Friday, next Friday.
Tomorrow, madam.
Next Friday, next Friday.
Well,
Next Friday.
Thursday, Lordship.
Thursday, too many matters are fixed. Have it
Lordship,
on Friday.
yes.
My lord,
Only on that question you can come back. Yes.
As regards prayer, Lord.
my lord, I am extremely sorry, my lord. I missed my item number 19, my lord. It's a part hard matter, my lord, may fix in the next week, my lord, on Tuesday, my lord.
Some date will be given. Some date
Tuesday,
will
my
be
lord.
given.
Thursday?
No, some date will be given there.
Thursday morning. Tuesday to Thursday morning.
Friday.
Some hearing day will be given.